brief break. I'll tell them that
Okay.
due to the nature of the next witness, the defense has to set up some stuff, and we'll take a brief break.
Okay.
So we'll do our short witness, assuming the jury is all here.
Yes, sir.
They are? Oh, all right. Well, they're ready. Is the state ready for the first witness?
Yes, Your Honor.
Defense ready for the first witness?
Yeah, she's in the room right now.
All right, we'll get the jury. We'll do the first witness, and then I'll tell them we need to take a brief break to set up for the second witness.
Thank you, Your Honor.
You're welcome. And let the record reflect everyone is present, including the defendant, Mr. Keetley. Yes, we are.
All rise for injuring.
The jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good afternoon. Welcome back. I hope everyone enjoyed their extra time this morning for our late start. But as always, I will have to ask you before we do get started whether anyone discussed the case amongst themselves or with anyone else, or whether anyone was exposed to anything about this case between the time that you left the courtroom yesterday and the time that you returned to the courtroom this afternoon, by a show of hands. Let the record reflect that, again, there are no hands. Excellent, and thank you all very much. We are now, actually, I'm going to let you know, just for timing purposes so there are no surprises, the defense is going to call a witness, and then after that witness, we're going to take a very short break because they have some stuff that they need to set up for the next witness. So rather than it being awkward while they're doing that and everyone's just sitting here, we're going to let you go back there and stretch your legs while they do that. It won't take very long. But I'm going to ask them now to call their next witness.
Thank you, sir. We call Jackie Burgess.
Jackie Burgess.
Burgess, yes, sir.
Good afternoon and welcome, ma'am. If you'll come forward to be sworn, wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you. Do you swear or affirm any testimony which you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. If you'll follow the bailiff to the ramp that leads up to the witness chair, please watch your step. There's some cords on the floor. When you get to the chair at the end of the ramp, go ahead, have a seat, make yourself comfortable. That microphone there in front of you is adjustable. It moves up and down. We find that it's probably best to be level with your mouth so it projects your voice when you speak. All right. Mr. Grant, you may proceed.
Thank you, sir. Good afternoon.
Good afternoon.
Would you turn and introduce yourself to the jury, spelling your last name for the court reporter, please?
My name is Jacqueline Faith Burgess, spelled Burgess.
Ms. Burgess, do you know someone by the name of Michael Keetley?
Yes, I do.
Do you see Michael Keetley in this courtroom today?
Yes, I do.
Would you please point him out and describe what he's wearing for the record?
He's over there on my right. He has on a sweater and a shirt, a blue shirt.
Your Honor, may the record reflect this witness is identified Michael Keetley.
The record shall so reflect.
Thank you, sir. So I'm going to ask you first how you know Michael Keetley, but it may be better to start this way. Does Michael Keetley have a sister?
Yes, he does.
All right. And do you know his sister?
Yes.
Who is she?
Her name is Jessica.
And Jessica is married to someone. Who's that?
My son, Stephen.
All right. So are you Jessica Hadley's mother-in-law?
Yes, I am.
And is that how you know Michael Keetley, excuse me.
Yes, it is.
All right. How long have you known Michael Keetley?
The first time I met Michael was at Jessica and Stephen's wedding over 25 years ago.
Do you recall what year they got married? I know you said over 25 years.
1996.
Do you recall how long your son and Jessica were dating before they got married?
Through college.
Throughout
Well,
that-
actually, they started out in high school.
I hear you. Throughout that courtship in high school and into college, had you ever met Michael Keetley?
I had moved away to Pensacola when my son started college. So, and I just came down here for the wedding, and then I moved back here in 2003.
I'm going to turn your attention briefly to November 25th of 2010 as a signpost, okay?
Okay?
Do you remember that day?
Yes, I do.
And that day was a holiday. Do you recall what holiday it was?
Thanksgiving?
All right. So I'm going to stop you. Well, let me ask you this. Did you see Michael Keetley on that day?
Yes, I did.
Let me go backward a little bit. How many times before that November 25th of 2010 day would you say that you'd been around or exposed to Michael Keetley?
Maybe half a dozen times at other holiday dinners, and my grandkids, which are his niece and nephew, at their birthday parties. He would be at some of them.
Do I hear you say at family functions or get-togethers?
Right. That was.
Did you ever socialize with Michael Keetley on his own?
No.
Would you describe, excuse me, I think you said 2003 you thought the wedding was?
No, the wedding was in 96.
96, I'm sorry. I had 2003 in my head.
I moved back to Brandon in 2003.
Very good. So from that wedding in the mid to late 90s to 2010, is it your testimony you'd maybe been around him a half dozen times or so?
Right after I came back to live in Brandon, yes.
Very good. So did you have the opportunity to see and observe how Michael Keetley interacted with people, notably your grandchildren?
During, the times when I've
Prior
seen him
to-
before. Oh, yes, of course.
All right. Can you give an idea what his physical movements were like in this 2003 to 2010 area?
He was fine as far as I knew. I didn't see any physical disabilities.
Did he engage with his grandchildren and other family members?
Objection, Judge Relevance.
His niece and nephew.
Wait.
Hold on just a minute.
No, I'm going to overrule that.
Let me ask you the question again. Did he engage with his family members or his grandchildren prior to 2010?
My grandchildren, his niece and nephew.
Gotcha.
Yes.
I've got the family tree messed up. I'm
Okay,
sorry.
it's okay.
It would have not been relevant had it, so now it's relevant that he's restated it.
Thank you. All right, so there are grandchildren involved. They're yours. Michael Keetley's around them, right?
Yes.
And tell me what you would see.
Well, if it was a Christmas occasion, he would like help them unwrap their presents, put their toys together, interact with them, play with them.
All right, so now I'm going to take you to 2010, that Thanksgiving.
Okay.
Is that the first time you had seen him in a while?
Yes.
All right, and I'm going to try to play with your memory to see how far back a while was. Do you recall how long it had been since you had seen him in November of 2010?
Probably about 2 years. He came to my granddaughter's birthday party. She was 4, and he came, and it was at my house.
And if you recall that birthday party at your house for your granddaughter, was he walking normally, using both hands, engaging with his grandchildren, or your grandchildren?
Yes, he was.
As far as this November of 2010, we're not going to talk about what, but had you heard about an incident where he had been significantly injured?
Yes, I did.
Right. And obviously you were not a witness to that armed robbery and attempted murder, were you?
No.
Right. So if anything, and we're not going into what, anything you heard about that, was that from somebody else?
Yes, it was.
All right. So when you saw him on November 10, in November of 2010 on the 25th, had that shooting and attempted murder already happened between the last time you saw him? Did that question make sense?
Yes.
All right. So the last time you saw him, somewhere in 2008, he appeared to be fine. Is that right?
Right.
And so now in 2010, you've heard things, and this is the first time you've seen him.
Right.
All right. Can you tell the jury on that November 25th, 2010 day, where did you see Michael Keetley?
At my son's house for Thanksgiving dinner. We had it early.
All right. We're going to talk about it being early in just a second. But you go to your son Stephen's house, is that right?
Yes.
Stephen and Jessica?
Right.
Who else was there that you recall?
The Keetleys and Michael's parents and Michael and just my son and his family, Jessica and the grandkids.
All right. So you, the Hadleys, and the Keetleys being the parents and Michael, is that right?
Right.
Do you have a recall about how Michael appeared and acted that day?
They were there before I got there.
Let me stop you there. Let's get a time frame, please. You said it was early. What time did you arrive for Thanksgiving?
Around noon.
And why was the Thanksgiving meal going to take place around noon on that day?
Yes.
And why was that?
Because I work at the hospital and I had to be at the hospital at 2 p.m. to be at work.
Did you have a work shift that day?
I did.
All right. And so because you had to be there at 2 o'clock, the Thanksgiving celebration with the Keetleys and Hadleys and yourself was going to be early so you could be a part of it?
Right.
All right. And I think I heard you say that you got there around noon? Is
Right.
that your recall, somewhere around there?
Right.
All right. With that backdrop in mind, at noon, around noon of November 25 of 2010, did you see Michael Keetley?
Yes, I did.
Describe for me what you observed about his physical appearance.
Well, when I got there, Michael was sitting in the living room, and I didn't really see him do anything other than sit down and have dinner with us because I was not there very long, only about an hour or so. So we just pretty much immediately started to serve dinner when I got there. Lunch, whatever you want to call it, Thanksgiving dinner. When I got there, and we all sat down at the table and ate.
Did you notice anything about his right arm?
He had a brace on his right arm,
Okay.
on his hand, and up his arm.
Okay. Did you notice anything unusual about his demeanor?
No, I mean he was the same Michael I was used to seeing. Obviously hadn't fully recovered from the injuries he sustained from being shot. I could tell that.
So when you talk about recovery and you talk about this brace, did you see him able to use his right hand?
No,
Okay. When you sat down, when I say you in the collective, when you sat down for Thanksgiving, did you observe Michael at the table?
yes, he sat next to his mother.
Okay. And what did his mother do?
Well, she did have to help him cut his turkey and ham. We had both, I believe. The meat up for him to eat.
Was he able to use his right hand at that meal?
No, not that I saw.
Okay. Was he using his left hand to scoop up or collect his food?
Yes,
Okay. Was his mother helping him throughout the meal?
well, yes, basically.
Whenever he needed it?
Yes,
All told, would you have been there for a couple hours or so?
probably not even a couple hours. Maybe a little over an hour.
You got to
Because I had to get to the hospital. I had to be there by 2.
Let me ask you this. You've described his physical appearance. At any point in time when you got there, any observation you made of him, was anything unusual or out of the ordinary other than the physical that you've described?
No,
Okay.
nothing.
I may have a moment here, okay? Thank you, Ms. Burgess. I have no further questions.
Cross-examination.
Good afternoon, Ms. Burgess.
Good afternoon.
You didn't see the defendant use his right hand that Thanksgiving Day meal, correct?
No,
And you don't know if he could or could not use his right hand or his fingers, correct?
no,
And that brace that you described, you said covered his hand and his wrist and went up his arm.
yes,
Okay. And so you don't know if he was not wearing that brace, whether or not he could move his fingers or not.
no.
May I have a moment, Your Honor?
Yes.
Nothing further.
Redirect.
Anything you saw, did it seem like he was faking an injury?
Objection, Judge.
Legal basis.
Relevant to speculation.
I'm going to sustain.
Did you see anything to indicate that he did not need that brace?
No,
Nothing further.
May this witness be released by the state, by the defense,
Yes, sir.
and the state?
Yes, Your Honor.
Thank you, ma'am. You may step down and you may be released as a witness at this time.
thank you.
You're welcome. Ladies and gentlemen of the jury, we're going to take that short break now before we call the next witness. Please not discuss the case amongst yourselves or with anyone else. Please not do any research related to the case, and please avoid all reports of the case outside of the courtroom. All rise for the jury. Jury has exited. Everyone may be seated. So it's still a little bit before 1. Is the doctor actually here?
He just finished surgery. He has just texted Kim to let her know that he should be here by 1:30.
Oh, 1:30.
Just
Okay.
got out of surgery. I guess there was a complication in the surgery.
Okay. All right. Well, then the break's gonna be a little longer. Let's go ahead, though. Obviously, you'll have plenty of time to set up for him. We'll bring the jury back in as soon as he gets here. But I think there was an indication that there was a couple of issues that needed to be discussed.
Yes, and Ms. Khan just stepped outside, I think, to call Dr.
We'll wait for you. You don't need to rush her,
Okay.
Mr. Escobar.
That was Dr. Howard.
Doctor's running late.
Yes, he had some unexpected complications. He had surgeries this morning,
Okay.
so he had some unexpected complications in one of the surgeries. But he's running home now to get his suit and heading over here. He said 1:30 is reasonable. I apologize.
It's all right.
Couldn't be expected.
I don't think I need to bring them out and say anything to them. They just will, as usual, sometimes when we take breaks, they're longer than expected. I'll apologize to them when we bring them out. But I did want to discuss, you said there were a couple of minor issues, and then you'll have plenty of time to set up.
Right, I think we can discuss those. That's what I was going to bring up, Your Honor.
I think, Ms. Hodges, are you on the other side of the doctor?
One of the issues, Your Honor, was defense exhibit number 18. I think it actually becomes even more relevant in light of Ms. Johnson's questioning and Ms. Burgess. And may I
Is it a
approach Your Honor so you can
photograph,
see
or-
them?
Yeah,
Yes.
you may.
These were introduced at the last trial, and I know just because they were doesn't mean anything. These are two records,
They're progress notes.
two progress notes from a Dr. Barossi post the incident. One is December 8th, very short in time. One was March of 2011, again, close in time, within less than 5 months. Again, just reaffirming his right hand paralysis. And in light of the fact, I think it becomes even more relevant that there may be some argument that he doesn't have right hand paralysis, that he could use that right hand, that he doesn't have the limitations that are going to be testified to. I think it becomes even more relevant that now even if we just go with the December time period, which is within days, probably within a week or so of these murders, it reinforces the fact that you now have another provider saying this man has right hand paralysis. I think
Who's going to translate these? I can't read all these notes.
Dr. Halpern will, as he did last time, and he certainly will this time.
What is the state's objection? Is it relevance?
Judge, that's part of it. So it's relevance for the most part. So when we're looking at these records, what's not evident is whether the defendant had continued with any sort of physical therapy, wearing braces, things of that nature, which the lack of that information and the lack of that either apparatus or assistance could result in a deterioration of his condition. So when we're talking about these records, they're past the time frame of when the incident occurred. And we're accepting that he has limitations in his right hand. We're not hiding from any of that. We recognize that that is a fact in this case. So when we're looking at these records, they're past the date of offense. Some of them are as far removed as March. And so when we're taking into consideration he's now in a jail setting, and we can't cross-examine the doctor on, okay, if you're in a jail setting and you're not able to receive the medical attention you would have previously, does that cause a backslide in abilities?
Well, won't you be able to cross-examine Halpern on that without putting jail setting? If you're not able to receive the follow-up or not doing the treatment, would that result in a deterioration of the condition? Can't you ask Halpern that?
I don't know. I'm not sure that he's going to be able to answer all of that because he was not the treating physician at that point. I think he can probably give some opinion on that, but when he doesn't know what was and was not received at that point, it just becomes pretty dicey that we're getting into an area where when he was questioned, I believe it was on cross last time, there was a question posed to him, and the answer to someone who was paying attention was that the defendant was, I forget the exact word he used, but it was something to the effect that he was in a lockdown facility and the doctor was able to go visit him one time. And so
We want to try to avoid that.
and that's my concern is we're dancing really fine on this line when we're going into records that go all the way out through March and what his treatment may have been, the doctor's knowledge of what that treatment may be or lack of treatment and what the results may be. It's very difficult for us to effectively cross-examine on that without suggesting to the jury, you've been treating him for a year, suddenly days after this offense, you're no longer the treating physician. It becomes a very slippery slope that I'm not looking to put the doctor in a position of suggesting in any way to this jury that the defendant is incarcerated.
Well, I don't think that I can limit you, and I don't know the defense is asking you be limited of establishing that he was not treating him at this time. You were not treating him at this time, were you? And you don't know what treatment was or what follow-up, and he's going to say, I don't, and then he's essentially an expert on the subject, so if he can't answer the question of if he wasn't doing what he was supposed to be doing and what Dr. whoever was telling him to do, would that result in a deterioration of the condition? I mean, I can't think of a better person to be able to answer that, and you can establish that he can't say whether he was or he wasn't. And well, I don't want to go any further than
Then
that.
if the court's going to allow those records in, I would ask of defense that we talk to Dr. Halpern ahead of time and let him know that there's going to be no question from either party that the answer is the defendant was incarcerated.
Totally.
Definitely, yeah.
Totally
I think
agree.
you all should talk to him,
Okay.
show him
Totally
the
agree.
notes, and but.
And then he can walk through the testimony accordingly
agree.
without saying anything
And
about
and
that.
the reason I'm doing that ruling, not because they came in before, but from what I heard from your position regarding relevance, I think that you can effectively handle that on cross of him, the issues that you wanted. If he wasn't doing the things he was supposed to be doing or wearing the bracelet he was supposed to be wearing, isn't it true that, because it's cross, that would a deterioration of the condition? And I mean, Halpern's an expert, and I trust that he's going to answer. And you can establish that he just can't say what he wasn't treating him, and he can't say whether he was doing the things he was supposed to be doing or not,
Okay.
without saying that he was incarcerated.
Thank you, Your Honor.
We'll talk to Dr. Halpern about
All right.
that and make sure that he's clear on
Yes.
what his answer needs to be.
Not a problem. And then the only other item was on cross, Ms. Hodges wanted to present to,
Not present.
Or-
So what I want to do is I want to I want to ask Dr. Halpern ahead of time about modification kits. The testimony came out on cross-examination of Wesley Smith and through direct examination about a modification kit. It was elicited that it could be a RONI, and then get into some of the features of that RONI. I want to talk to Dr. Halpern ahead of time. I by no means intend to use this as a demonstrative aid, but I did want to show this to the doctor so that
He has
had
an idea of what you're talking
Correct.
about when you question about modification kits.
Correct.
well, the problem though is that RONI and that modification kit, as has already been established, was not available in 2010. So with all due respect, that
Well, I mean, maybe not. That was a
Yeah.
very slippery slope. But some indication of modification kits. So certainly they can question him about modifications to guns.
I think if he's familiar with it, and I guess if they're specific, but that is, we know if they get into a description of a RONI, we know that that's unavailable in 2010. So that's completely inappropriate. If he's is familiar, I guess there's basic testimony of modification kits, but we're getting into speculation now on behalf of Dr. Halpern. I mean, they're going to have to be. I mean, was there any specific testimony? I'm not familiar with any specific testimony other than the words modification kits. So now you're going to have an expert to come in and say, well, what is the modification kits going to be doing? Because he's talking about the usage of his hands, right? So is it something that he's going to be using with his left hand in conjunction with his right hand? Is this his left hand only? Is it his right hand with conjunction with his left hand, with the use of his shoulder? I mean, there's a lot. This isn't just the words modification kit, Your Honor. I mean, we're talking. This is the definition of speculation.
Well, but it's cross-examination. They can give hypotheticals in cross-examination, just like Mr. Escobar gave hypotheticals in cross-examination of one of their experts. And so they can include, I mean, I don't want to put the words in their mouth, but they can certainly give all the hypotheticals they want, including their knowledge of what a RONI looks like in a hypothetical situation. It's an expert. So I don't think he needs to be shown that, but you can cross-examine him as an expert, and you can give him hypotheticals. If this, then what? If this, hypothetically, if I don't want to finish the question.
Well, my intention is absolutely not to show this to him in trial in front of the jury. It would be outside with defense counsel present prior to his testimony to say, hey, if you saw something like this, what are your thoughts?
Well, I mean, I understand that there was the issue of whether it was available or not, and that's exactly why the Roney guy was not able to testify. So I'm concerned about the exposure of the witness to that. You can describe things that you're ultimately going to use hypothetically, but without showing him an actual one, that there's no currently testimony or even basis to believe that that one was available. But there were discussions with Mr. Smith that Mr. Smith testified to about questions about modifications to firearms that would, I guess, allow someone with an injured hand be able to use the firearm.
May I respond to the court on a couple points of that?
Sure.
So prior to Ms. Clark testifying, defense did in fact show her a separate firearm and ask questions of her outside the presence and asked her to do some research on that. And so she was then asked questions regarding that specific make and model in cross-examination. Additionally, for the Roney, the state did not put forth testimony from Jay Ports because his answer was going to be possibly the Roney would be available. It was not a definitive answer.
Right.
The state made the decision that that was not testimony we were going to put forth in front of this jury. However, that does not preclude that there could have been this model available. And my intention when I'm questioning Dr. Halpern in front of the jury is not going to be, was the Glock 21 Roney something you were familiar with, but more talk about the features of it and being able to show him something, a picture's worth 1,000 words, just to say, this is where I'm going with these questions so that you understand what I'm asking you. That's my purpose for showing him at least the diagram of it.
And ultimately then, is that going to be a part of a hypothetical to him if...
I'm not going to use the words, so my intention would not be to say, I showed you something earlier, and it's a Roney for a Glock 21. No, it would be...
not allow that.
No, and this is just so he's got an idea of what I'm talking about. My questions are going to be far more generic.
What you're talking about when you do what, though? When you say...
When I asked the doctor on cross-examination because he testified previously, he was asked about modification kits.
Okay, see, I don't remember that.
So when he was both on...
I'm not surprised, but I don't specifically remember.
Both on direct and cross-examination in his prior testimony, he was asked about firearms, his experience, his use, pistols, shotguns. He was shown the rifle that's in evidence. He was asked, is this something that the defendant would be capable of shooting? His answer is yes. So my questions are going to take that line of questioning and go a little bit further with it. When we're talking about specific modification features that would allow somebody with limitations to be able to more effectively use a firearm. Not going into this, Glock 21, Roney, things like that.
So you agree that Halpern is going to say or said previously that he could fire a rifle?
No, Your Honor. That's why you probably saw my face blink.
No, I didn't. I wasn't looking at your face.
No, he did not. What he said was he could use his left hand to fire a firearm. He could not use his right arm. He testified he could use his right hand to prop up one. When he was shown that rifle, he specifically testified that he would not be able to use the rifle because of the shoulder injury he had. So he even demonstrated it for the jury. So
wow, I don't remember any of that.
Yeah, yes, sir. So I respectfully disagree with Ms. Hodges' interpretation of that. I also reread that this morning of that. So we can respectfully disagree.
Well,
with
is
that.
he going to say that he could prop up the back of a rifle with the one hand and fire it with the other?
He could. What he could testify to is he could likely shoot with the left hand.
Shoot with the
left hand.
left hand.
He
And
could
prop up
probably
with the right.
hold up, something which I think Ms. Doherty asked him on cross-exam, if he could hold up something with his, a firearm with the right hand, if he, a firearm.
Or a rifle.
I don't think it was
butt.
asked specifically a rifle. When that was presented to him, he did do a demonstrative that he would have problems putting that in his shoulder because he has impingement of the shoulder, and we'll go through that later today with that. But anyway, we're kind of getting far afield on this. We're going back. I mean, I agree. If the court is going to say, hypothetically, if I guess Mr. Keetley had a firearm with, the pistol grip in here with the right hand doing this, I think we have to be specific about where the hands are or what the hands are doing in these hypotheticals.
Or even specifically a firearm that was the subject of a conversion that made it similar to a rifle. I
guess so.
mean, I think that's where you're going with it, right?
It is.
So-
Because he does, and Ms. Khan's correct about that he has limited motion in his right shoulder. He would have to stabilize it. But when asked the question, is this something he would be able to do with his left hand, referring to shoot that rifle, his answer is, well, so that requires both hands to stabilize. He would have to really, with his left hand, place it into his right hand first, and then he would be able to fire the trigger, certainly repeatedly, with the left hand.
Well, and I mean, I see, and the problem in the end, and it's, what I think both sides are aware of, the only evidence of that is idle chatter of such a conversion kit.
Right.
So, that's the problem in arguing to the jury, and it's the state's burden. But I can't prevent those questions, and those questions were asked apparently previously regarding modifications.
I will state over objection, Your Honor, just for the record.
Well, like what? That they can't ask about modifications?
Well, there was a question about modifications. We objected to speculation, and things were kind of narrowed down. And because was he familiar with it, and we kind of went through that.
Well, but he's an expert, right?
Right,
I mean, you're going
and-
to present him. You're going to ask him opinions.
And we're there, and he's familiar with firearms, and I think that's why Ms. Doherty asked him and brought out the rifle, because he has some familiarity with firearms, and it was brought
Well,
out.
yeah, I mean, and that adds to it. And again, as an expert, they can present hypotheticals. If this, then what's your opinion?
And I respect that, Your Honor. So I just wanted to be clear on that. I just wanted to make sure Roney's not going to be mentioned.
Yeah,
Photographs aren't going to be up
Not-
there. If we're in the
Not
form
going to
of
allow any of that.
if we're in the form of specific hypotheticals, this type of feature, this and that being.
Well, it sounds like she's going to keep it pretty general, which appears to be along the lines of if a handgun can be modified to be similar to a rifle, then what's your opinion? Is that correct?
That's correct. What's the court's ruling on whether I'm allowed to show
I'll
those
let you show it to
photos?
him, but you're not showing it to the jury. You're not
Not my
talking
intention.
about Roney, anything specific. You got to keep it really general.
Absolutely, that's my intention.
But similar to, I guess, what you said the defense did with one of your experts, I'll allow you to show it to him. But
And here's another concern, Your Honor. Do we even know what the weight of that is? Because one of the concerns is that, and Dr. Halpern will testify to this, is that because even in the left hand, and Dr. Halpern will testify to this and has testified to this previously, is that even his left hand had decreased grip strength and things like that. So do we even know the weight of this modification that she's going to show him? We don't know anything about it. We don't know the width, the trigger strength. We don't know anything.
well, and that's why she's not going to be able to ask specific questions regarding that or show that to the jury. But again, some of those are appropriate. Then you'll have the opportunity to redirect him and get him to say again that, all the things regarding the weight of the hypothetical alteration that the state has no proof of would or wouldn't be effective dependent upon the weight of the non-existent or fictional
Which
modification. Again, I don't want to put words in. I could easily do the director the cross of this witness, but I don't want to put the questions out there. I look forward to seeing it.
All right, thank you.
And you all are both excellent attorneys, so I know that it'll go extremely well.
Thank you, Your Honor. I'll, just trying to see if I got any
So
updates.
actually, that's going to take a few more moments than when he gets here. Well, the best I can do is when we do bring them out, I'll take full responsibility for the length of the break.
Yes, I'm just texting him again the directions. That's why I'm texting Your Honor.
Oh, I know. How about if we at least enlighten on the potential jury instruction, special instruction issues? I received case law from the state, but I did not receive a proposed special instruction. The case law, there's three separate types of case law. One is regarding the excusal of the juror. One, and then the other two were regarding instructions, and some of those were on special instructions, and some of those were on deterioration or destruction of evidence, but didn't have instruction stuff. So I suspect that the special instruction is somehow related to destruction of evidence, but I have no idea what evidence is proposed that it was destructed.
So sorry, on that we sent, about 7 o'clock this morning, Ms. Villamil sent an email. We thought it went to the state, or I thought it went to the state, it did not. I talked to Ms. Johnson about 10:15 or so, and we forwarded on for their review. I did not send it to you first. I wanted to get there.
Did you get the case law, though, that they sent to me?
You just referenced that, and so the answer to that question is yes. It came at a time where I'd already left the office, so I'm now seeing it myself. So I'd like to take a look at it.
Okay, all right. Well, we don't have to argue that. Now, but can you enlighten me on what the instruction, the proposed instruction is?
So what I was going to say is, if you don't mind, I'll go ahead and forward you the proposed instruction. I wanted to
I'd
get
love
the
it.
state's feedback first, so I'll forward that to you so you have that.
Okay, all right. I appreciate that. And other than that, then I guess we'll have to be in recess until the doctor's ready. So just let me know. I'll be right down the
I
hall.
think you did.
Probably around the same time Jen sings.
So if you want to address that,
What's that?
Whenever you're
can
ready.
we approach the bench?
Yeah. we have everybody. Is the witness ready?
Yes, Your Honor.
All right, are we ready for the jury?
Yes, Your Honor.
Stay ready for the jury?
Stage ready?
Let's get the jury.
Since I was in your class with them.
Art, actually have you.
Oh, did you have one of the officers?
Yeah. Yeah.
As a couple.
Yeah. Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. I take full responsibility because I said short break, and if I do that, inevitably everything will go wrong. We had some technical difficulties we had to take care of and other issues I had to discuss. So I take full responsibility. Please do not hold it against the parties, the attorneys, or anyone else. But we are ready to have the defense call their next witness. But I do have to ask before we begin, was anybody exposed to anything about the case, or did anybody discuss anything about the case during the last break by a show of hands? Excellent. Let the record reflect there are no hands. Again, thank you all very much for your attention, your patience with us, and your very important service. I will now ask the defense to please call their next witness.
Thank you, Your Honor. Defense calls Dr. David Halpern.
Dr. Halpern. Doctor, you're already in the courtroom. Come on down. Good afternoon and welcome, Doctor. If you'll raise your right hand before you head over there. Get over there in a minute, but there you go. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, Doctor. Now you can head over there. The bailiff will indicate. Watch your step. There's cords on the floor. Go ahead, have a seat in that chair. It looks like you've got a bag. You may have some reports to unpack. You go ahead and take your time. You let me know when you're ready.
Okay, thank you. I'm ready.
All right. You may proceed.
Thank you, Your Honor. Please state your name for the record.
David Eric Halpern.
And Dr. Halpern, what do you do for a living?
I'm a plastic and hand surgeon.
And could you please give us a little bit of a background of your education?
How long do you have?
Not that long.
I finished my undergraduate degree at the University of Pennsylvania.
We'll stipulate to correct.
I'd still like to go through a little bit. Thank you, Your Honor.
I graduated with a Bachelor of Arts degree. Then I attended New York University Medical School, where I got my medical degree in 1987. And then did a full general surgery training at Maimonides Medical Center in Brooklyn, New York.
I went on to do a 2-year research fellowship at Children's Hospital Los Angeles for 2 years and the Center for Craniofacial Molecular Biology. Then I did a 2-year fellowship in plastic surgery at the University of Southern California. After that, I did a 1-year fellowship in hand and microsurgery at Columbia Presbyterian Hospital in New York.
Are you, have any memberships in any societies?
Yes, many.
Can you just name a few?
The American Society of Plastic Surgeons, Florida Society of Plastic Surgeons, American College of Surgeons, the Florida Medical Association, the Hillsborough County Medical Association, the American Society of Peripheral Nerve.
And what about the Florida Hand Society?
That no longer exists, that defunct. That went out about 10 years ago. About several years ago, I'm sorry.
And are you the president of the Florida Society of Plastic Surgeons currently?
No, I just finished that tour of duty in 2022.
Do you hold any staff privileges at any hospitals?
Yes, Tampa General Memorial Hospital, which is South Tampa HCA, and Advent Hospital, Carrollwood.
Are you board certified?
Yes, I am.
In what area?
I'm board certified in plastic surgery with certificate of added qualifications in hand surgery.
And tell us, what did you need to do in order to obtain your certificate of added qualifications in hand surgery?
This is a very difficult, probably the most difficult certificate to get. You have to complete a residency in general surgery or plastic surgery or orthopedic surgery. After that, you have to do 1 year in an accredited fellowship where you're just doing mostly hand surgery. And then when you graduate, you go and do a certain number of cases per year. You have to do a certain number of cases per year, usually 2 years it takes you to get that. And then you have to sit for an exam. To sit for that exam, you actually have to do not just a number of cases like carpal tunnels or little cases, but you actually have to qualify in 6 of 9 categories that they list, like tendon surgery, microsurgery, congenital surgery, pain, fractures, all sorts of different hand problems. And then you have to take a test, which is, for the past 40 years, has been the highest failure rate of any board exam given to become certified CAQ in hand.
Is it fair to say you have a specialty within a specialty in hand surgery?
Yes.
And are you currently an associate clinical professor anywhere?
Yes, I'm both an associate clinical professor at USF here in Tampa and also at University of Florida. I'm a clinical professor.
Are you the chief of the Department of Plastic Surgery anywhere?
Yes, at Tampa General Hospital currently.
Now, you have met with me in this case?
Several times.
Okay. And what have we discussed?
We discussed how Mr. Keetley presented when I saw him first, his surgeries, his follow-ups, test results, x-ray results, prognoses, capabilities.
And you have testified at a prior hearing in this matter, correct?
Yes, I have.
And I wanted to correct something. And for that testimony review of the records, is it fair to say that after that you were testified, it's fair to say that you were provided some reimbursement for your time?
Yes.
Now, typically, what do you charge for your time if you were to testify at a hearing or a trial like today?
Well, we have since we interact a lot with attorneys, we have a fee schedule that we basically give to attorneys before we even interact with them. So it makes it fair that they understand what the commitments are as far as time and money. So, for instance, a deposition might be $1,200. A half-day of testimony in court, I think, is $8,000, and then I can't specifically say what a full day would be, but more than that. So we have an actual sheet that, if you want, I can provide it. I guess we can always attach it. I didn't bring it. Didn't think it would come up. And
is it fair to say that previously, because of the work in this case, that you reduced that rate to $500 an hour for your prior testimony at that last hearing?
That's correct.
Do you recall how much you were reimbursed?
No.
We have to ask your office manager.
Please.
And in regards to today's testimony, you recall you were previously scheduled to testify a few other dates, but we had to move you?
Yes.
Okay. And did you have to cancel surgeries and other patients? Clear your
Yes.
schedule?
I had to reschedule a full day. I had canceled.
Well, are you planning on charging?
I'll allow just a little bit. Just finish
Great.
that.
In regards to your time, are you again going to be asking for reimbursement for your time here today?
Yes, we will ask on the backside of this, yes.
And again, are you planning on reimbursing at the same reduced rate of $500 an hour?
Yes.
Now, in anticipation of your testimony today, you reviewed several medical records.
Yes.
All right, I'm going to show you what's been previously marked as Defense Exhibit 16, Defense Exhibit 17, Defense Exhibit 18, and Defense Exhibit 19. So I'm going to bring up your demonstrative aid from your office for you. I'm sorry, Your Honor, I forgot to ask you to approach.
Oh, you may.
I apologize.
No, not a problem.
Have you previously reviewed those records, Doctor?
Yes.
Okay. And Defense Exhibit 16 appear to be a true and complete copy of the Tampa General Hospital records for Mr. Keetley that you reviewed.
It looks to be.
At this time, Your Honor, we'd like to introduce Defense Exhibit number 16.
Any objection? It'll be admitted.
Defense Exhibit number 17, does this appear to be a true and correct copy of your medical file for Mr. Keetley?
Yes, it does.
At this time, we'd like to move in Defense Exhibit number 17.
Any objection to 17?
No objection.
Defense 17 will be admitted.
Please take a look at Defense 18. These are the two clinical notes of another primary care physician who saw Mr. Keetley. Those appear to be the two notes, the true and correct copy of the two notes that you previously reviewed.
Yes.
At this time, we'd like to introduce Defense Exhibit number 18.
Any objection to 18?
Nothing other than previously stated.
All right, defense 18 will be admitted at this time.
And I'd like you to look at Defense 19, Composite 19. Do these appear to be a true and complete copy of x-rays taken at various times at Tampa General Hospital of Mr. Keetley?
Yes.
At this time, Your Honor, defense would like to move in Defense Composite 19 into evidence.
Any objection to 19?
No objection.
Composite 19 of the defense will be admitted.
Now, Doctor, as part of your role as a treating physician, are you required to review medical records, including reports of other physicians?
Yes.
From information that you reviewed, do you recall what hand dominant Mr. Keetley was?
Right.
Now, let me show you. Do you recall when you first came to meet Mr. Keetley?
Yes.
And that was at Tampa General Hospital?
Yes, I was the attending hand quill surgeon.
Okay. Let me show you what is, we just introduced into the record. And this would be in Defense Exhibit 17, Bates Stamps 21 currently. Now, when we look at this, this is a consult note. And what is a consultation note?
So just part of the process of the Tampa General trauma, the way it works is when someone comes in with multiple gunshot wounds, not just of the hand, but of the chest, the trauma service is the admitting service. So that the hand service is a consulting service. Just like if he had a head injury, you would have a neurosurgeon see him. If he had a bladder injury, it would be a urologist. So the hand service is a consulting service. We're not the ones that are actually totally in charge of his care. So that's why it's labeled a consultation report.
And under the history of present illness, where would you obtain this information?
From direct examination and from my residents and fellows that work with me.
And according to the information that you have in the history of present illness, where was Mr. Michael Keetley shot?
Well, he was shot in the hand, left hand. He was shot in the right upper arm. He was shot in the shoulder, the leg, and the left chest.
Now, under the extremities, you examined him, correct, in different parts of the body?
Yes.
You did a physical exam. What did you observe under his extremities? What did you observe at the time?
So just a little basic science, when you have a gunshot wound, and especially in an extremity or elsewhere, when you have in his left hand per se, so if something enters in the palm of the hand, it'd be a very clean, small hole, and then it impacted structures, and then the exit hole is always much larger because the bullet's been disturbed. It doesn't have an exact path, so the larger wound, usually the exit wound of where the bullet exits. So we saw 2 opposing wounds in the left hand. That's what's described first.
And it says with surrounding ecchymosis. What's ecchymosis?
Bruising.
Now it says right upper extremity demonstrates inability to extend digits. Can you explain that to us?
Sure. So I'm going to use this model just to help. So just some basic definitions of finger flexion is when you bring your fingers down. Finger extension is when you bring your fingers up. Thumb flexion is when you bend your thumb like this, and thumb extension is when you bring it back. So he was in a posture where his fingers were just flexed. His thumb was actually into the palm, and his wrist was flexed down.
And is that what you mean when he says he does have weakened flexion?
Yeah, he had some weakened flexion as well. That's concomitant with his injuries. People tend not to move very much when they have this type of trauma. It's painful.
Now, you also note that he had right shoulder, let me pull this up. Always doesn't want to cooperate. Let me do it as a single. There we go. Right shoulder with swelling and ecchymosis. Did you also observe that?
Yes.
Okay. And what does it mean here with the left hand with, can you read that to us?
The X-ray report or
With
the
left hand with linear, oblique, what does that mean?
So linear means like a line.
Okay.
Oblique is a direction, so like vertical will be straight up and down, horizontal will be straight across, and oblique would be kind of in the middle.
And the dorsal wound, what does that mean?
So dorsal is on the back of the hand, and the measurements are in centimeters, in inches. If you wanted to convert that, would be like 4 inches by almost an inch.
So he had an open wound about 4 by 1 inch on the back of his hand?
Yes.
And he had an exposed, what's that mean? Exposed EDC tendon, what does that mean?
It's time for Latin. Most anatomy is in Latin, so that's extensor digitorum communis.
Okay. So basically, the wound was open enough that you could look in and see his tendon?
Yes.
Is that fair? Okay. Now, according to this also, there was an x-ray with a fracture.
Yes, there was.
And let me show you what is previously been marked as a part of Defensive Composite Exhibit 19. This was an x-ray taken of that left hand on the 23rd. Does this x-ray show a severely comminuted fracture?
Yes, so comminution is a description of a fracture type. It's not like just a clean cut or a break or an angular cut. It's just basically smashed. So you're just seeing fragments of the bullet, which are very white looking, little speckled parts. And then there's really no intact bone circumferentially at all in that middle metacarpal bone.
And what is all those, and if you ever need to stand, Doctor, you want to make Dr. Halpern stand if he
Yeah,
needs
you
to?
can step down, doctor, and there's a yardstick up there that we use as a pointer on the railing. Oh, right over here.
Right here, Doctor.
Oh,
Oh,
Got it.
What are these, like, white things that we're seeing all of you, and that big chunk of white thing? What is that?
So that's basically the bullet. When the bullet contacts the bone, it shatters the bone and also shatters into all these little pieces that you see. So all these little white parts are flecks of lead, which really are very radio opaque. And you see the bone is basically in 100 pieces here. There's no real impact. Very good bone.
If you could stay there one moment, Doctor, I want to ask you about, let me show you another x-ray that was taken that same day. This was also taken on January 23rd of his right arm. What are we seeing here?
All right, so this is the shoulder up here, and this is the humerus, which is the long bone of the upper arm. There's the elbow. And this is exactly where the bullet shattered, hit his bone and shattered it into at least 6 or 7 different pieces here. And then you can see here the remnant of most of that bullet is located in the x-ray.
Thank you, Doctor. Now, as part of your role as treating physician, did you perform a procedure on Mr. Keetley on January 24, 2010?
Yes, I did.
Let me show you your operative note on January 24th. And now, what procedure did you perform on him?
So in these type of trauma cases, it's very, very important to assess the neurovascular function. There's so many things so close in the hand that are in a small space that so many things can be injured by the same projectile. So the number one thing initially we always worry about is infection. So the most important first part of this type of procedure is an irrigation and debridement. Debridement means that you're basically cleaning the wound. You're removing it of devitalized bone or tissue or skin or foreign body like bullet fragments. Then you're washing it out. You're cleaning it with sterile saline, usually a pulse irrigation set. So it's really the first part of this type of trauma procedure is an irrigation and debridement, very standard. The second part that's listed is fixating the bone. So the way his bone was, there's no way that it could be completely fixated. There was a large defect in the bone from the blast and trauma of the bullet.
And let me stop you there because I think lower down in your description of the procedure we have that information. So according to your operative note, approximately how large was that defect of the bone?
Well, you know, in the first look operation, we only take what's obviously not viable. So 3 centimeters, which is over an inch, was definitely not viable. And a lot of times we will go back a second time, or during a second procedure, we may have to even remove even more. It's certainly possible. But at that time, it was 3 centimeters.
And this was of the left hand?
Yes, of the left hand.
Now, who is Dr. Roy Sanders?
Roy is the chief of orthopedics at Tampa General, and he's the head of Florida Orthopedic Group.
Now, in your role as a treating physician, did you review Dr. Sanders' progress notes, operative notes of Mr. Keetley?
We actually had a discussion before any surgery happened. We kind of plan out how we want to do his surgical care. So that's a yes for sure. Since he had open fractures of his left hand, we had to address the left hand first, and then Dr. Sanders was planning to go the following day to address his right arm.
Let me show you. So you would have had an opportunity not only to speak with Dr. Sanders about Mr. Keetley, but then also review his medical records and progress notes and operative notes as well.
Absolutely.
All right. And what... What surgery did Dr. Sanders perform on that date?
Well, I'm sure he did some type of debridement as well, but they basically reduced the fractures of the upper arm and placed plate and screws, and also performed a nerve exploration.
Right. And it does say here an incision and debridement, correct, of the radial nerve
I'm
exploration?
sorry, I didn't see that. Yes,
I'm here to help.
thank you.
Now, and in here, it also discusses conversations with plastic surgery. Would that have been you?
Yes.
Now, in the second page, which would be, for the record, base stamp 26, it kind of goes into a little bit more detail. Now, what is a grossly contused radial nerve which was in continuity? What does that mean?
It's a hard concept to understand, so it's going to take a little explaining. So, gunshot wounds are different types of traumatic wounds. It's not like a stab wound where something just gets cut and that's it. It's very clean, sharp entry, exit. Gunshot wounds are high velocity missiles, and when they strike tissue, it's not just the hole they make, but there's a tremendous zone of injury around that hole. And then when it impacts a bone, it sends a tremendous shock wave through the soft tissues. So there's the bullet wound, and then there's the zone of injury around that area that occurs. So it is certainly possible that the nerve could appear absolutely physically intact, but that actually the inside of the nerve is mush. We call it a SEDEN type 5 class nerve injury because the nerve's not cut like a knife would cut a string like of spaghetti. So the string is still intact, but everything inside that string is totally mush. It's almost like an electrical cable that has the insulation on the outside and the electrical wires on the inside. The insulation's intact, but everything inside's like melted together. It's just, there's nothing that's in continuity.
Is this a minor nerve injury?
No, this is a major nerve injury.
So is it fair to say that the zone of injury is much larger?
Yes, it is.
Did Mr. Keetley have what's known as a blast injury to his right radial nerve?
That's one way of saying it, yes.
Can you explain to us what is a blast injury?
It's kind of like a shock wave.
Can anything be done surgically to repair this type of high radial nerve blast or shock wave injury?
No.
Let me show you this x-ray taken on January 25th, 2010. Now, this would have been post Dr. Sanders' surgery.
Hard for me to say if it's post. It could either be intra-op at the end of the procedure or in the recovery room.
Okay. But we see, I'm guessing those are the staples.
Yeah, the staples are on the outside of the skin.
Now, the x-rays, it's fair to say, would not show the radial nerve.
Not at all.
Okay. Let me show you what we have as a demonstrative aid, so you could explain to us how the radial nerve can be impacted by a blast injury to the upper arm. If you could explain to the jury.
Can I get it?
You may sit down, yes.
So, hopefully this will demonstrate to you a little bit in at least 2 dimensions a little better, but always now I'm using 3 dimensions. So the radial nerve is one of 3 major nerves that innervate the extremity of the arm. All these nerves come from the cervical spine of the neck. They coalesce in the brachial plexus just between the neck and the shoulder. And then they divide into 3 major nerves. So the radial nerve comes out here and it basically wraps around this humerus bone right here. And right in the zone of injury is exactly where this nerve is. It's really applied right to the bone and kind of snails around to the back side of the forearm. When it crosses the forearm, that's when it starts innervating muscles on the back of the hand and back of the forearm.
So 1 second, Dr. Halford. So where we're seeing, may I borrow this stick?
Sure.
So where we're seeing the blast here is where the radial nerve would be impacting around here?
Yes.
Okay, thank you. I'll read that later. Now, is it fair to say this is part of Defense Exhibit 35? Would this be a photo? This is a photo introduced of Mr. Keetley post-surgical. Would this be in line with a post-surgical photograph of him, of the healing of that surgery that Dr. Sanders performed?
Definitely shows the incision.
Now, the surgery that Dr. Sanders performed, let me ask you this. Without the radial nerve functioning properly, would Mr. Keetley have any ability to extend the fingers in his right hand?
No.
Without the radial nerve functioning properly, would he have any ability to extend the thumb in his right hand?
No.
Are those opinions within a reasonable degree of medical probability?
Yes.
Now, after Mr. Keetley was discharged from Tampa General Hospital, did you have an office visit with him?
Yes, I did.
And I believe your first office visit with him was on February 10th, 2010?
Yes.
And again, according to this, you note that he is right-hand dominant?
Yes.
And is this just introductory, just a summary of what went on in the hospital?
It's a summary and then obviously progressing to his outpatient status.
So at that time, what were your observations to, I don't know if I went too far, to his left hand?
Well, observations that someone has a complete palsy of the radial nerve or paralysis of the nerve, where they're in a certain posture. The posture is of the lack of inability of the fingers to be extended, so they're in this kind of almost mostly closed position. The thumb is close in, and the wrist is actually hanging down. He has no ability to either extend the wrist either. He also had numbness in the sensory distribution of the radial nerve, which is in the back side of the radial half, or this thumb side of the hand.
And I wanted to correct myself. I said left, I meant right. And so you were responding for what was going on with the right hand and right wrist, correct?
That's correct.
And is there a difference between a high radial nerve palsy versus a low radial nerve palsy?
There's a huge difference.
What's the difference?
There's a difference in prognosis. So it has to do with distance. It has to do with prognosis. So, for instance, a low radial nerve palsy would be one maybe in the mid-forearm or even lower, where people would actually excise an area of nerve that was traumatized and do a nerve graft and expect that nerve to grow at a reasonable time to reinnervate those muscles so it could work. Or leaving it alone, the body might actually do that on its own, because nerves regenerate at about 1 millimeter a day rate. In high radial nerve palsy, all of these muscles are denervated. In a low radial nerve palsy, maybe only some of them are, and it takes an extraordinarily long time for the nerve to grow back from the upper arm or mid-arm to these muscles, because it's a certain time frame that they have to reach the muscles.
Ms. Staffield, you used the word denervated?
Denervated.
Denervated, what does that mean?
So a muscle's kind of like needs input from a nerve to work. It just doesn't happen on its own normally. So it's almost like throwing a light switch on or off. If there's electricity and you throw a light switch on, the light's going to go on. Well, if the connection between the nerve and the muscle is severed, was not present, even if there's electricity from the brain to go through the nerve to reach the muscle, it never gets there. And the other problem is that the end motor unit, the thing that receives those nerve signals, degrades over a certain time. So that over about 6 months to 9 months period, even if that nerve heals and reaches the muscle, there's actually nothing in that muscle to receive that nerve input that's new. So it has to do with distance, rate of recovery, the amount of muscles affected, the amount of atrophy of the muscles that are affected over time as well. Because if you've ever been in a cast when you take that cast out, one arm looks like a shrink arm, the other one looks like your Popeye, because you haven't used those muscles atrophy. Okay, even in a short time of a cast of 4 to 6 weeks, it takes a lot of people a long time to recover from that.
So is the prognosis worse or more difficult for high radial nerve palsy?
Absolutely yes.
And is that the type of nerve palsy that Mr. Keetley had, a high radial nerve palsy?
Yes.
You note that at this juncture he has complete radial nerve palsy, both motor and sensory. What do you mean by that?
So these nerves, like the radial nerve, are mixed nerves. What that means is that they have functions that are both of motion or motor function, and also some sensory nerves that provide sensation to the skin.
And at this time, is his radial nerve functioning properly?
Not at all.
Now, without the radial nerve functioning properly, did he have any ability to extend his wrist?
No.
Did he, and again, can you show us what position his wrist would have been in? Did he have any ability to extend his fingers?
No.
Did he have any ability to extend his thumb?
No.
Are those opinions within a reasonable degree of medical probability?
Yes.
Now, you talk about here that we will not plan to transect any tendons and make these, I skipped it. Recommendations will be based on probably early tendon transfer to improve function of the right hand and act as a babysitter. What do you mean by that? What's a babysitter?
A babysitter is a term that we use to improve function, but we're not cutting any of the receiving tendons because we think he may have some recovery. We're not sure that he will or will not have recovery of some nerve function over a reasonable period of time. So we actually are able to take a tendon from a side of his forearm, which is actually functional, and move it over to the back side of the forearm to at least improve the positioning of his wrist.
And I believe at that time you discussed with him the potential for the nerve transfer.
Yes, I did.
And at that time, what did your note discuss in regards to what Dr. Sanders told Mr. Keetley?
Well, he felt that the nerve recovery was uncertain, and he felt that it's unlikely that he would have very good function of his hand.
Now, at this time, it's fair to say you did a second surgery on Mr. Keetley.
Yes, we did.
And I kind of want to go through these one at a time. And this is in March 2nd, 2010. Now, let's go through the first one. What was the first surgery that you performed?
So a lot of times we will do multiple procedures on a patient who has multiple needs. It allows us to address certain issues at the same time and actually hopefully makes their recovery quicker. So in part one, we addressed his left hand. Remember I said he had a large bony defect that we basically spanned with some wires to just stabilize the one piece of bone that was still left. That first part is actually taking a bone from his hip, from the iliac crest, which is in the front part of your hip. We actually took a 4 centimeter segment of bone out.
Give me one second, I'm going to pull that up for you. Give me 1 second. I think I have that here. And that's part of your operative note. So, and that answers that. So the iliac crest is a part of your hip?
Yes,
Okay. And approximately 4 centimeters is how much in inches?
almost 2 inches.
Almost 2 inches, okay. And so you would have done a surgical procedure on that hip as well?
Well, it's actually the pelvis, and we actually make a small incision overlying the anterior pelvic brim, and we actually get to the bone right away, and we use osteotomes to cut a segment of bone out, and then that's used as a graft to the hand.
All right, going back. So that was the first procedure that you performed? Is that correct?
So when we do that, we actually take the bone out, we close the hip, we take that bone, we shape it, and we actually then have to recreate the hole because a lot of the hole fills in with like scar and fibrosis, and then fit in that bone in between the two segments of bone that are remaining, and we fixate that with plates and screws, and you can show them the x-ray if you want to show them that.
Let me get to that one. Sure. You're ahead of me. Is this the x-ray you're referring to?
So that was the x-ray after I fixated his bone, with the bone graft, and you can see the wires going across, and then there's a plate and screws as well. I don't know if you can see the plate and screws on that view, but there's a second view.
All right, so let's go back to,
There you go.
see it a little bit larger. I can make it a little bit larger for you.
Excellent.
Perfect, good, all right. All right, let's go back to your surgery. Have we finished discussing number one?
I think so.
Okay. All right. Wait, that wasn't it. I went back too far. One second. There we go. All right, let's talk about number two, coverage of bone graft with a tenaglide. What is that?
So Tenaglide is basically like collagen, like a sheet of collagen. It actually comes from, I think the source is cow. So it's technically a xenograft. That's a definition of where a graft comes from. If it comes from human source, it's called allograft. If it comes from cow or a pig, it's called xenograft. So that's a xenograft. But it has no cells in it. So what we do is we wrap the extensor tendons in this because we don't want the extensor tendons to stick down to the bone graft. We want tendons to glide very nicely. That's how they move. They glide in little tunnels. So it's a very common thing to do when you have extensive bony work under exposed tendons is to place something called Tenaglide.
I'm going to let you read number three all on your own.
Need a Latin lesson, huh?
Yes, I do.
Pronator teres to extensor carpi radialis brevis tendon transfer right forearm.
Okay, what does that mean?
So we're basically, the concept of tendon transfer is probably about 100 years old. It was fashioned by a couple of very smart orthopedic and plastic surgeons to address either birth defects or nerve palsies. So it's kind of the concept of what a lot of plastic surgeons are, which are kind of described as Robin Hood, where we kind of take from the rich and give to the poor. So remember I said that there are two other nerves in the arm called the ulnar and median nerves, and they innervate this side of the forearm. They allow for flexion of the thumb and the fingers. They allow for flexion of the wrist. There are also other muscles that allow for other functions of the arm, such as pronation, when we put our palm down, or supination, when we kind of pull our wrist up. These are different muscles in the forearm now, innervated by different nerves other than the radial nerve. So we can take some spare parts because there are lots of tendons that do flexion. There's two muscles and tendons that do pronation. So we actually take one of the muscles that does pronation, called pronator teres, which is innervated by the median nerve, which is like what gives you carpal tunnel, and we can actually divide that tendon where it inserts in the forearm and reroute the muscle to the back of the forearm and actually skewer it through the midsection of the extensor of the wrist. When we do that, you're taking a muscle that's graded 5 out of 5 power, and you're decreasing it by at least 1 grade. So there are 5 grades of muscle power. 3 is barely able to keep up with gravity. 4 is weaker, not as strong. 5 is full power. So when you're taking a muscle from a different part of an arm and you're rerouting its line of pull, and you're attaching it to a different tendon, it loses some of its mechanical advantage, but it still is useful for positioning and some strength. So that's exactly what we did. We were able to kind of get his wrist up into a more normal collinear position with his forearm at least.
But fair enough to say it still would always be weaker.
Yes, always.
Even after I'm just going to call it number 3. Even after number 3, was Mr. Keetley able to extend his fingers?
No,
After the surgery, was he able to extend his thumb?
no,
Was any tendon transfer ever performed to Mr. Keetley for his thumb and finger extension?
no, it was none.
And number 4, appears you removed a bullet from his back?
Yes.
Now, looking at the discharge summary for this hospitalization, it discusses that he was happy or pleased with his increased ability in that wrist, a more favorable wrist position. Do you see that?
Yes.
Okay. Now, it does state that he's the increased ability to extend his right hand digits in light of a favorable, more wrist position. Could you explain to us what you mean by that?
So there's something that's called tenodesis. Y'all going to be hand surgeons after this. My God. So if you put the wrist, if I just kind of move my hand back and forth, you can see that if I'm just moving my wrist, my fingers change position. And actually, if I extend my wrist without even trying to move my fingers, it kind of flexes my fingers more, not extends them. There are lumbrical muscles that can kind of, in this position of flexion, can slightly extend the fingers with these fingers flexed. That's not a radially innervated function. It's actually part of what we call lumbrical plus function of a hand, which is ulnar and median innervated. So even though he's in a better position, his fingers are actually more flexed than they were before. And he may be able to kind of slightly extend these fingers, but that's about it.
So even though he had a little bit more movement in the wrist, did he have the independent ability to fully extend his fingers?
Not even partially extend, really.
Did he have the ability to even partially extend his thumb?
No.
Are those opinions within a reasonable degree of medical probability?
Yes, they are.
Now, after this, you again saw Mr. Keetley back at your office on March 8th.
Yes, I did.
According to this, anything different going on with his right hand?
Well, I think he had some inflammation, not necessarily infection, so we saw him earlier than expected.
But nothing different really going on with that right hand, still in the same palsy happening?
Yeah, nothing's changed as far as that's concerned.
Your next visit was March 12th, and I believe this is the post today after the bone graft and tendon transfer.
Yes, a lot of times when you take bone from a hip, it's really painful, and they can get cellulitis, which he had, but with antibiotics and with warm soaks, it resolved. So this is 4 days after.
Now, you talk about that I've shown him some passive range of motion exercises. What is passive range of motion?
So passive range of motion is kind of when I take maybe my hand that's not injured, and let's say if this hand is injured, and I start actually moving things with the other hand. I'm moving them with my left hand, my right hand isn't moving anything. And the reason why we like to start passive motion in someone who is paralyzed is to keep the joints mobile. The best analogy I can give you is a door on hinges. That looks like a great door over there, but if the hinges are rusted, it's not going to move. So we have to actually keep these joints mobile so that if and when it comes time to either transfer tendons or have a nerve recovery, everything will work.
And how is passive range of motion different from active range of motion?
Well, I mean, if I'm actively moving something, I'm telling myself, let's move, and I'm moving it. Passive is when I'm passively doing it. It's not doing it itself.
What are contractures?
So contractures are describe diminished motion. The diminished motion can be because of many different things. So, for instance, in burns, we get burned in the skin then heals by contracture, and the hand can't move because the skin's like a rock. Or in a case where you have an injury to a joint or a bone. There's nothing wrong with the skin, but that bone has healed or created an internal scar across the joint or across the tendon, and again, it diminishes the motion.
I think in here you talk about that he appears to have a slight contracture of the MP joint.
That's correct. So metacarpal phalangeal joint is the joint that is the first joint of the finger between the finger and the metacarpal. So it would be this joint right here. This is the joint I was talking about, the middle finger.
And just generally for the hand, can, and the word just went out of my head. Braces, there it is. Can braces be used on a person's hand to reduce the risk of contractures?
There are two different types of braces that I think you're implying on. One is a static and one is a dynamic splint. So static splints basically position the hand hopefully in a position of function so that it rests in a position of function. Dynamic splints actually help position, and the patient can kind of do some motions and it will actually return for the patient. So if a patient can flex, we can actually make a splint that has rubber bands underneath so that when the patient stops flexing, the splint extends the fingers on its own.
Even if a person, say like Mr. Keetley, if he has using splints or braces, is that going to affect his palsy due to the high radial nerve damage?
No. The only thing that these splints do is help keep things in a functional position or have improved ability to move when something else happens. It won't allow a nerve injury to heal.
At this time in March of 2010, was Mr. Keetley capable of active range of motion in his right fingers at this time?
Well, only for flexion, not for extension.
Was he capable of active range of motion for extension in his right thumb?
No.
Did you observe at this time anything going on with his right shoulder?
He was very stiff.
You note that he has a diminished range of motion, is that correct?
Yes.
All right, and we're going to go in a little bit more detail on that a little bit later. But let me show you, and I think we were talking about the splints. There was a video shown to the jury earlier on of, and I don't remember the state's exhibit, it was a Channel 10 video, but let me just show you a still photograph, and it was from that video. In this, we can see Mr. Keetley's fingers open. Can you explain that to us?
I'm going to show him. I have to go up and show him.
Yeah, absolutely. You sit down anytime you need to.
All right. So what I was saying is that the splint is elevating his fingers forward because you see here there's a spring action here. So he has to be able to place his fingers into this, and then he has the ability to close this, which puts this spring on a stretch, and then when he relaxes it opens his hand back up for him. He's not doing that. The brace is doing that for him. This has been placed in his hand, and his fingers are placed in this part of the splint, so it allows him to have some active motion, and then his fingers are being passively extended by that splint.
So really, is it fair to say that this splint is really doing the work in actively extending his fingers?
Yeah, it could be misleading. You might think that, oh my God, he's moving his hand, but it's the splint is doing the extension for him.
And is that opinion within a reasonable degree of medical probability?
Absolutely, yes.
Is it fair to say that your opinion back in March and April of 2010 is that Mr. Keetley did not have the physical ability to actively extend his right hand, fingers, and thumb?
That's correct.
Now, in this photograph, is there anything interesting about his thumb positioning?
Well, his thumb positioning is characteristic of someone who can't extend his thumb. So you can see his thumb at the MP joint, which is right there. That's flexed, that's not extended. So that's flexed like this. I'm not doing anything with my thumb. My extended thumb position would be something like that. So if his thumb position was extended, it would be up that high. That's totally flaccid, and it's basically just being held in by this bar that goes across his hand.
Let me show you your next visit was April 14th, 2010. It looks like you reviewed some x-rays.
Yes.
Okay. And it looks like this time you recommended some massages and continuing on with passive range of motion.
Yes.
And be fair to say, would this be the x-ray from the 13th? I think you kind of briefly went over this with the jury earlier.
Yes. So this is bone graft that's incorporating really nicely. It's in anatomic position. You can see the plate and screws right here. There's still some bone fragments in here. These pins are used to maintain metacarpal height so that it doesn't collapse and it stays in line with the arc of his hand, which is a bit of a semicircle here, if you can see it. So he had good anatomic position, he had good incorporation of the bone graft, he had no incident infection, he was in a good path for recovery of his hand.
Let me show you what's also part of Defensive Exhibit Composite 35. This is a photograph, and you can see the stitches on his left hand, but the positioning of his right hand, is this consistent with the testimony and the opinions you've rendered to us today?
You know, I don't think I've ever seen that picture before. That's probably the best picture you can show, showing his hand kind of in a flexed position, not extended, his thumb and fingers are hanging straight down. So this shows this. If you wanted to show a resident this or someone on the jury, you can see that in a position like this where it's hanging down, gravity is actually working against him. Okay, it's not helping him; it's hurting him. There's no way that those fingers can come up or that he can bring that wrist up in this position.
And is this due to the high radial nerve palsy?
Yes.
Is that opinion within a reasonable degree of medical probability?
Yes, it is.
Let's go to May of 2010. Now, according to this, does he still have diminished range of motion in the MC joints?
Yes.
Does he have any recovery of the radial nerve at this time in his right hand?
No.
With no radial nerve recovery, does he have any ability at this time to extend his right fingers?
No.
Does he, with no radial nerve recovery, does he have any ability to extend his right thumb?
No.
Are those opinions within a reasonable degree of medical probability?
Yes.
Now, in here it also talked about an upcoming surgery of a closed capsulotomy, and let's talk about that. You performed a closed capsulotomy on June 1 of 2010.
Yes.
What is that?
So, a lot of times when joints don't move a lot, they can become really stiff. It has nothing to do with the joint itself other than the fact that it has been moving. There are a lot of accessory ligaments, collateral ligaments that are around joints that shorten if the joint's not bent. So if I took any of the jurors and I put you in a splint at the start of this trial, and I left you in the splint for 2 weeks, I'll assume it's been, 2 weeks you've been here? You would not be able to
Not
bend
more
your
than that.
finger. You would not be able to bend your finger if I took you out of the splint, even though you had nothing wrong with your hand before then, believe it or not. And I would have to manipulate you or get you into therapy to get that motion back. And you may never, ever get that motion back because you've been immobilized in a position of non-function. So this is a secondary effect of having a gunshot wound, being immobilized, having multiple surgeries, pins, screws, plates. And then when everything heals, we then go back and say, wait a second, everything's healed, but it's not moving the way it should in his left hand. And it's because of scar. We heal by scar. And so what happens is the tendons get stuck to the bone somewhere, the joint's not moving the way it should. So a closed capsulotomy is me basically sedating a patient or knocking them out and basically going, like I bend it and I break all those adhesions and I make sure it moves well. Okay, I don't have to necessarily cut, so when we do a closed capsulotomy, that's exactly what we're doing. We're basically manipulating a joint to get it back to motion. Even though there's nothing wrong with that joint, there's some scar tissue around it. I don't have to worry about an unstable bone or a tendon or anything like that. I'm just moving that baby so I can get going again. So that's exactly what a closed capsulotomy is.
And what's the number 2 that you performed?
So number 2 is the tendon actually sticking to something. So tendons usually glide in a groove. It's almost like a piston in a cylinder. It's a really exact fit. And if anything perturbs that tendon from sliding, it's gonna get stuck by scar, because that's how we heal. So sometimes we have to open up the incision in a small area, actually find the tendon, dissect it circumferentially so that when we pull it, the finger goes like this and it's sliding well. Again, I don't have to immobilize that patient after that surgery because nothing is broken. I don't have to worry about it. So I can free that tendon up and it can go.
Looks like the next visit you had with him was in June of 2010, post those surgeries, correct?
Yeah, that was a follow-up for his left hand, and it was to also order an electrical test for his right.
We're going to go through those in more detail a little bit later on. But what was the purpose of the EMG?
So EMGs are a way for us to non-invasively monitor nerve function and nerve recovery. It allows us to identify in patients if there's continuity of the nerve, if the nerve is functioning, if the muscles are denervated, if the nerve is recovering. All those things.
July 9th is your next visit. Let me. Now you note that his EMG shows some evidence of marked recovery of the proximal musculature. Just generally, and again, we're going to go through this in more detail when we pull up the EMGs. What does that mean?
All right, basically medical school liturgy again. So you're all going to pass a test. So proximal is close to the body, distal is far away. So proximal muscles, in the right arm would be these proximal muscles, like his triceps and his, some of these muscles in his upper arm and shoulder area.
And what was your recommendation for how often he should receive these EMGs?
Standard care is typically every 3 months. We recommend repeated studies to mark the progress of nerve recovery or lack thereof.
And why were you stating that you were not going to perform any further tendon transfers until you see further evidence, the lack of future evidence of reinnervation of distal musculature?
Well, at this juncture, it's still about 4 months after, almost 5 months after his injury. He's still, nerve recovery is about 80% in about a year. My thoughts were probably he would need more tendon transfers, but at this juncture, we might as well wait it out.
And at this time, in July of 2010, did he have any ability to independently extend his fingers in his right hand?
No, we did not.
And at this time, did he have any independent ability to extend his thumb in his right hand?
No.
And are those opinions within a reasonable degree of medical probability?
Yes.
Now, in your notes, there is a physical therapy discharge note. Do you recall that?
Yes.
Okay. And he had completed what is known as all of his formal therapy.
Yes, at this time.
And when we say he's completed his formal physical therapy, what do we mean by his formal physical therapy?
So formal physical therapy is actually going to a place, you're having a therapist supervise your therapy, they're helping you do the exercises, they're stretching you, they're massaging the scars, they may give you certain things to try and do, certain tasks. There are multiple modalities done in therapy. they stretch. So this is a regimen that we have patients do initially because very many of them benefit greatly from it. They can't do these things on their own, or they have diminished ability to do it.
And when he's still, even though he's discharged from formal physical therapy, he's still capable of doing at-home exercises.
Oh, absolutely. They're sent home with a home protocol. They give them a sheet. They give them a schedule. So yeah, there's big emphasis on transferring formal therapy to home therapy.
Now, according to this, how many visits was Mr. Keetley seen for?
50.
And just going through it, they had done an evaluation at the at the time of his discharge, which was on August 25th, 2010. Now, what was his grip strength?
So grip strength is done by something called a JMR dynamometer. It's actually this device that you actually grip. They set it to a certain distance, and it actually measures the grip strength in certain settings. So here his grip strength was, I believe, I'm trying to find it, 72 pounds on the right and 91 on the left.
Now, I think you talked about that previously. Mr. Keetley was right-hand dominant.
Correct.
Right. So, for a man at the time, his age, generally speaking, what is a normal grip strength?
Oh, about 140 pounds, dominant hand.
So, at this time with his right hand, he is 50% weaker than a normal.
Probably at least 30 to 40%, yeah.
Now, does grip strength equal finger strength?
No,
Does grip strength equal thumb strength?
no.
So one has nothing to do with the other?
Well, grip strength is a composite of a lot of things. It has to do with some finger strength because you're using the fingers to clamp down, but it's a multimodality function. It's one way to measure strength in the hand.
What about the strength in his left hand? Is that below normal as well, even though it's stronger than the right, but is that below normal as well?
Yes, it is. So we typically see about a 10% difference in dominant versus non-dominant. So if he's 140 on the right, he should be like 125 or 130 on the left.
Is it fair to say that his right is significantly weaker than his left?
Yes.
Is there a difference between flexing fingers versus picking something up?
Oh, absolutely.
What is the difference?
So we're kind of built to grab things. That's kind of how we're built. The flexor muscles are much stronger than the extensor muscles. So the extensor muscles are made to position the hand so that we can pick up things. If you can't extend your wrist or extend your fingers, you're not going to be able to grip anything because you can't put the hand and the fingers in the proper position to grip something. So even if you had normal grip strength, you wouldn't be able to position properly to grip anything unless it was directly placed in the hand.
Is it fair to say for picking something up, must you have wrist extension?
Yes, crucial.
In order to properly pick something up, must you also have finger extension?
Very important.
In order to properly pick something up, must you also have thumb extension?
Yes, because what happens is they get in the way. You can't get them out of the way. That's the problem.
So in August of 2010, now I know we've talked about the prior months, but now moving forward to August of 2010, was Mr. Keetley able to actively extend the fingers in his right hand?
No.
Was he actively able to extend his right thumb?
No, it wasn't.
Are those opinions within a reasonable degree of medical probability?
Yes.
Was he able to, you were talking about moving his fingers out of the way, was he able to move his thumb out of position?
No, it was not.
What would have been his right hand posture or position at that time in August of 2010?
Something like this. He could pretty much hold his wrist into a neutral position, but it's like what I was saying before. If you're in neutral, actually it puts your fingers more in flexion than extension. If I'm in a flex position of the hand, the fingers come out because of purely a tenodesis effect. It's not a conscious effect. I'm not doing that. My fingers are just connected, and because I'm shortening the distance on this side, I'm lengthening the distance on this side, and that's why these fingers kind of straighten out, not because I'm telling it to. You can try it on your own. You can see that if you just kind of move your wrist back and forth, you'll see that your hand either straightens out or your fingers flex without you doing anything.
In August of 2010, would Mr. Keetley have been able to pick something up with his right hand?
Very unlikely.
Is that opinion within a reasonable degree of medical probability?
Yes.
If Mr. Keetley at that time wanted to hold something in his right hand, how would he go about holding an object, let's say a bottle?
Well, you would have to basically place it there. with his
And
right hand.
I'm going to, if you don't mind, may I approach, Your Honor? You used my water bottle as a demonstrative aid. Could you demonstrate for the ladies and gentlemen of the jury, if he wanted to hold my bottle, what would he have to do?
He'd have to be able to place it to hold it.
Okay.
It's much easier than fumbling around trying to get it himself. It's a much more coordinated effort when using a much more functional hand to place it into his hand.
Okay. So he'd have to use his left hand in order to place something into that right hand. He just couldn't use that right hand alone.
It's not an absolute, so he could possibly come down on something and then grab it. It's not a coordinated effort that you normally would see. It's a lot more coordinated if you're taking something and placing it to position it to then hold it.
At that time, would Mr. Keetley have been able to pick up a gun with using his right hand only?
It'd be very difficult to do that.
And is in that opinion within a reasonable degree of medical probability?
Yes.
Can you explain to us, in order for Mr. Keetley to have held a gun in his right hand only, what would he have had to do?
Possibly have the gun in some sort of stabilized position before he got to it, or using his left hand to stabilize it for him to move his hand over the right gun to then help him do it.
Can you demonstrate for us what Mr. Keetley would have been able to do in order to switch a gun from his left hand to his right hand?
I don't have a gun to show. I don't have a gun to show, but if he was holding a gun, he'd actually have to bring his hands together, or bring this hand over to then transfer it into his right hand.
Does the radial nerve allow us to grab?
It has nothing to do with grabbing, but what it does is it positions the hand so it's in a better position to grab.
And does it put the hand in a better position to pick up objects?
Yes.
Now, in regards to the range of motion to his right shoulder, was there any abnormalities?
Yes, there was.
And what were the abnormalities to his right shoulder?
Well, he had diminished, the biggest one was his lack or markedly diminished internal rotation of the shoulder.
And explain that to us.
So, shoulder motion is a little different than hand motion. So if we flex the shoulder, extend the shoulder, if we AB or abduct the shoulder, we're bringing it away from our bodies. And if we're AD or adducting something, we're bringing it towards our body. And then you have internal and external rotation. So you have external rotation where you're externally rotating, and then you have internal rotation. So if you need internal rotation, let's say to put your arm on your back. I mean, there's no way you could do that if you're only at 20 degrees. I mean, you can see what, 10, 20, here's 90, right? So 20 is only this. External rotation is 45, is okay. Okay, flexion extension is pretty good. 107 degrees of abduction, which is pretty good, which means you got pretty much almost full range of motion of abduction. 107 degrees of flexion, which is normal. So his internal rotation was really limited.
Let me show you the demonstrative aid that I have here. So I'm talking about his internal rotation. Let's talk about that a little bit.
Sure.
Can you do that? So his internal rotation, explain that to us in regards to being severely limited.
So, the initial neutral position is one like this. So internal rotation would be him bringing his arm in like this. External rotation is out. So this shows clearly internal rotation is limited.
And according to he was limited to, 20 degrees?
Yes,
And his external rotation was 45 degrees?
yes.
And I think in regards to, is this like someone, if he wanted to put your arm behind your back, would he have been able to do something like that?
No way. That would be extraordinary.
Why did he have limited range of motion in his shoulder?
Well, he had some damage to the muscles, that's number one. And then he had the fracture with scarring.
Now, given his limited range of motion with his right shoulder and your experience and training, would he have been able to hold a rifle with his right hand triggering the left and the shoulder stock in his right shoulder?
That'd be very difficult because he doesn't have the ability to rotate in towards the middle of the body. So it would have to be, if he was holding onto something, it would have to be kind of directly in front of him. Not towards the left arm, but the left would have to come to the right.
And is that opinion within a reasonable degree of medical probability?
Yes.
Now, the last time you saw Mr. Keetley in person was August 20th, 2010,
That's correct.
at your office.
At my office.
All right, and at this time, in regards to the right upper extremity, you wrote he still shows signs of marked radial nerve palsy.
That's correct.
And what do you mean by that?
Well, he's not moving his hands. I mean, he's not moving his fingers or his thumb. So it's the same old story that we had before.
And you write he still has absent finger extension and thumb extension, correct? Is that the same old story?
Yes.
And you write at this juncture he also has a Tinel sign to the mid-forearm. What do you mean by that?
So actually now, Tinel's, like I said, move at about 1 millimeter a day. So we can actually track the nerve recovery through to about the mid-forearm from his mid-upper arm. And that makes sense. If you take a measurement from his zone of injury, so if I use a tape measure, let's say, and we measure a distance from his point of injury in his arm to mid-forearm, it actually probably would calculate out to that ratio. So the Tinel sign shows that there's some advancing nerve function, but it's very slow. And even if it's right here, most of the Tinel sign that we find are mostly sensory nerve Tinels, not motor. A motor Tinels would be seen on an electrical test, which we also obtained.
We're going to go through those. Now, according to your note, at this time, I think you wrote his left hand is a closed deal.
Yes.
And fair enough, he would have had the ability to hold a gun solely using his left hand at that time.
I believe so.
And at that time, he would have had the ability to shoot a gun solely using his left hand at that time.
I believe so.
But not the same for the right hand, correct?
No.
And let's talk about a computer. Would he have been able to type on a computer solely using his left hand?
Yes.
What about, would he have been able to adequately type on a computer using both hands?
Very difficult.
Could you show us how it would have looked if he would have been using his right hand to type?
Because to type, you have to be able to bring the fingers up to type. So unless you're just using a pad, let's say
But let's use a keyboard.
no, you would not be able to use a keyboard, and that's only his right hand.
So in August, hypothetically, if fingerprints of Mr. Keetley were found on a cup inside his van that were for his left hand only and not his right hand, would that be consistent or inconsistent with your opinions today?
consistent.
Hypothetically, if fingerprints were found on a notebook solely of Mr. Keetley's left hands and none of his right hand, would that be consistent or inconsistent with your opinion so far today?
Consistent.
In August of 2010, would he have been able to tie shoes with shoelaces without any difficulty using both hands?
That would be another difficult thing to do with his right hand. See, that requires fine motor coordination between flexion and extension.
So let me show you. I don't recall which state exhibit it was, but there was issues. So in your opinion, would Mr. Keetley have been able to successfully, easily have been able to tie these shoes using both hands?
That would be difficult. It would be actually difficult also to put them on. Most patients like this have slip-on shoes. They don't have tie shoes.
Let me show you another state's exhibit. So in this state's exhibit, there are some slip-ons and Velcro shoes. So in fairness, these are the type of shoes that you would expect of a patient like Mr. Keetley, Velcro shoes and slip-ons.
Absolutely.
In your review of records, there was a, well, let me go back a second here. So still in August of 2010, he still has an inability to actively and independently extend his fingers in his right hand, correct?
That's correct.
And he still has an inability to actively extend his right thumb, correct?
That's correct.
Now, in your review of the records, did you review the x-ray taken September 7th, 2010?
Yep.
And I believe now, is this x-ray consistent with your opinions of why Mr. Keetley would have limited range of motion in that right shoulder?
So the x-ray doesn't really corroborate that. It gives a rationale, but it doesn't corroborate that because the x-ray shows the heart was in position. The x-ray shows that there's no fracture visible at any point in time. The bone is completely remodeled. It's in an anatomic position. It doesn't give, you can postulate that due to the trauma associated with having a plate and screws like this, that it could be the reason for stiffness, but just looking at the x-ray doesn't mean it.
Based on your experience in training and review of the medical records admitted into evidence and within a reasonable degree of medical probability, would the limited range of motion of Mr. Keetley's shoulder have likely remained the same from August 25th through November 25th if he no longer was receiving formal physical therapy?
Yes, it would have stayed the same.
And is that opinion within a reasonable degree of medical probability?
Yes, it is.
Now, I think we're going to go into it. You gave some orders, and this is an example of the orders you gave for EMGs and nerve conduction studies?
That's correct.
All right. What is an EMG?
An EMG is electromyographic recording of muscle activity. It's actually, they actually take like a needle, like it almost looks like an acupuncture needle. And it's attached to a wire, which is attached to a machine that's like a listening device. And so you could actually stick it through the skin into a muscle and then listen to the muscle. You can listen to the muscle at rest, and you can listen to the muscle during activity.
And what is a nerve conduction study?
So a nerve conduction study is usually done in conjunction with an EMG. So that tests the speed of the conduction velocity of nerve signals that are going either from the brain to the hand or the other way. So we typically measure coming back what we call regressive type of signals when we're looking at sensory function or sensory nerve action potential, and then we're looking at muscle or motor action potentials going from anterograde, like from the brain through to the muscle. So they actually put probes. certain
I
points,
think-
they measure the
I didn't want to say
distances.
that, I think I've got a demonstrative
Sure.
to help you on that. You want to?
Yes, they put probes on the arm, and they measure the distances. They know exactly how fast electricity goes. So they actually measure the conduction velocity through a nerve. So they can actually show whether it's conducting normally or if it's slow. And not only if it's conducting normally or slow, but where is it slowing down. So that's basically what this shows.
And is this kind of like the example you provided us earlier with the light switch? If you flip the light switch on, but there's no electricity coming through?
That's one aspect. So this actually is shows two things. It shows the needle that's actually listening to the muscle, which is that graph. So actually, you're actually listening to the muscle, and you're recording the muscle activity. That's the EMG. This, where you're actually stimulating, you're using a stimulating electrode over the nerve, and then you're recording the velocity, which is a nerve conduction study. Okay, it's two totally different studies.
Is there anything a patient can do to fake or cheat an EMG?
Never been shown to happen.
Is there
Possible.
anything a patient can do to fake or cheat their way out of a nerve conduction study?
No.
Why can't somebody fake or cheat their way out of these studies?
Because a lot of the muscle action is involuntary unless you tell them to do something. So it's just basically listening to the muscle. So a lot of muscles that are denervated or don't have normal innervation have what we call fibrillations. The muscles actually are just firing off like weirdly. And so it's a big sign of denervation when you have a muscle that's just basically fibrillating, irregardless of activity. So we can, part of this is like a listening station, basically. And then if we're asking the patient to do something, we should hear more noise, basically, in the EMG. The nerve conduction study basically is, I'm taking a shot, electrical shock, like a cattle prod, and I'm putting it to you, and then I'm putting recorders on, I'm shocking you, and it does its own thing. There's no way you can stop it, or you're powerless, basically.
Let's start with the March 1st, 2010 EMG. Okay.
Now you guys are going to become neurologists.
So let's talk about this a little bit. So it says what is a snap?
Sensory nerve action potential.
And it says the snap is absent. What does that mean?
It's just there's no feedback. There's no sensory afferent signal from that area of the skin back up through the nerve.
And is that an example when you're talking about there's this radial nerve palsy or?
Yeah, the nerve's not functioning at all for that sensory. And that's sensory. So the radial right snuff box is an area right here which only the radial nerve innervates. That's why they chose that skin. They know that anatomically, everyone in this room, the radial nerve, part of the radial nerve innervates the skin right here in the snuff box of your hand. Okay?
And what's the CMAP?
Compound muscle action potential.
Okay, and that was absent as well?
Yes, so they're looking at, here we go with Latin again, the right radial EIP. So EIP is extensor indicis proprius. So EIP is a muscle which actually extends the indicis, the index finger only. And that is solely innervated by the radial nerve.
Let's go to the June 28th EMG and nerve conduction study. So again, at least in June, the CMAP has severely reduced amplitude, correct?
That's correct.
And the snap is still absent?
Correct.
And what was the conclusion?
Well, it's a severe right radial nerve palsy.
Now, going over this is the second part of the 628. Can you explain to us what are we seeing here?
All right, so this is what I was talking about, listening to the muscle. This is the other part of the test, which is very, very important. So we're looking at innervation and reinnervation changes in some of the muscles of the proximal arm. So again, I got to get up here and show everyone. Sorry, Jack. So the deltoid is a muscle up here in the upper shoulder. You can see here that these molitional muffs are many in the deltoid, which shows that this muscle is recovering. And it's well on its way to almost a complete recovery. The biceps and the triceps here are definitely injured. But you don't really see, you see some slight increase in the duration of this, so they're not terribly injured, both the biceps and the triceps and the upper arm. But what you're seeing here, you see the spontaneous activity shows partial denervation of this muscle, or denervation with evidence of recovery. Here, in this extension digitorum communis, which is the tendon, the muscle and the tendons, that's 4 tendons that actually bring all the fingers up. You're seeing 3+ fibrillations and positive shock waves, fibs and PSWs, positive shock waves, which are signs of muscle denervation, but with no units of recovery. So this muscle, the deltoid, has been injured, but is well on its way to recovery and will have full function when you see this without doing anything. This is severely injured and has no evidence of any recovery at all. Okay, looking at the muscle. So there's nothing, no one's home. No one's home. It's injured, it's fibrillating, it's doing its own thing, and there's no evidence of any recovery. And this EBC, extension digitorum communis, which is the muscle that elevates all the fingers. There's 4 tendons that go to that muscle. Absent.
So going again in June of, based upon, let me go over one more. What are we seeing here on this graph? Let me just go over this real quick with you. What do we see here?
So this is just looking at amplitudes. So A1 is forearm, A2 is elbow, and A3 is spinal groove. I believe this is of the, let's see, EIP, so this is extension, this is recording one of the muscles. It's stimulating the forearm and the lateral brachia and axilla. So it's stimulating in different points, and it's just not a normal stimulation. So basically this is looking at, some of this is normal, so that you can see that the distance in millimeters, the EIP to forearm, the distance, the difference, the offset in milliseconds, and it's gonna look at a conduction velocity. Here there's no conduction to the forearm, none. Here it's still slow. Usually, conduction velocity of a normal nerve should be over 50 meters per second. That's the units here is meters per second. CP is conduction velocity. So you can see that there's really nothing going on again in the forearm, but that you're seeing some okay conduction in the upper arm area and the forearm elbow area, but nothing distal or nothing past this area.
So at this time, is there any possibility of Michael Keetley being able to use his right thumb to be able to extend at this time?
No, this is absolute proof that he can't. There's no electrical activity, past the proximal forearm.
And what about his being able to extend his fingers at this time?
No, that shows you also EIP is absolutely absent. There's no conduction, and there's no recovery of any muscle units.
Let me show you what was introduced as State's Exhibit 38, which is a photograph taken, I believe, around Halloween of 2010. In this photograph, Mr. Keetley, do you see his right hand over the shoulder of some young woman?
Sure.
His hand's open. How do you explain that?
Well, he's using his shoulder to posture his fingers, that's all. Doesn't mean he's actively doing it.
So this photograph with his hand open, does this in any way impact your opinions and the science that you've discussed with us?
Not at all. If she steps out of the way, his hand would probably remain just the same. He's not in an extension. His fingers are not extended. If you measure the distance or the angle from his metacarpal to his finger, that's about 70 or 80 degrees flexed position of his fingers. It's not an extended position of his fingers or his thumb.
The last EMG that you have is November 1st, 2010.
Correct.
And again, the snap is absent.
Snap is absent.
And the CMAP or CMAP, again, is reduced.
It's reduced, but his velocity is improving.
And what's the conclusion?
Well, he still has radial neuropathy. It's not changed, really. It's not changed much at all. See, in a lot of these cases of large nerve palsy in the proximal arm, what will happen over time, if we waited another year or two, he may actually have improved conduction velocity, but he won't have any active motor units. He may get sensation to come back over years. That's about it. I mean, if we did a study now, it may show more normal sensation. It won't show anything different than it is now, even 10, 12 years later.
And again, I know you don't have to, again, are we seeing the same or kind of similar outcomes as previously that you just went over us in June?
Yeah, so you're seeing the conduction velocities actually improve. These are all now what appear to be normal conduction velocity across the nerve.
Okay.
But you can see in the forearm, if you go back there, the forearm is
Right.
absent still. It's not recording.
That's what's going. So on the
Yeah.
forearm, where it has right there, it's
Everything-
blank.
Everything's improving here and here, but you don't see anything here.
So from the forearm down, there's no conduction, there's no
No.
nothing.
No.
So that would impact the hand, the thumb.
Hand and thumb.
And what are we seeing here?
Well, actually, this is again a recording in the snuff box. You can see that there's no sensory action potential at all. This is the recording of the sensory nerve action potential.
Is this another example where you would say no one home?
No one home. No response, NR.
On November 1st, 2010, based upon this test that one cannot fake, is there any possibility of Michael Keetley being able to extend his right thumb?
No.
Is there any possibility of Michael Keetley being able to extend his right fingers?
No.
Are those opinions within a reasonable degree of medical probability?
Yes.
At this time, would Michael Keetley be able to, say, open a bottle of medicine with his right hand?
Extremely difficult. Doubtful.
Would he be able to move large furniture using that right hand?
It would only be an assist hand. That's all it would be.
What position would Mr. Keetley's hand have been in due to the nerve palsy in November of 2010?
It really wouldn't have changed from the previously what I showed. So his wrist, he could probably maintain still neutral wrist position, but his hand would be just like this.
In your experience and training, is it at all possible that between November 1, 2010 and November 25, 2010, Mr. Keetley's right fingers and thumb paralysis would have improved to the point that he could actively and independently extend his finger and thumb?
No way.
Is that opinion within a reasonable degree of medical probability?
Yes.
Now, you have some familiarity with firearms.
Some.
In your prior experience, were you a police surgeon for any law enforcement agencies?
Yes. When I was training in Brooklyn, New York, we were police surgeons for NYPD Brooklyn South. And then when I was in Los Angeles, I was for the Sheriff's Department in Los Angeles County.
Based upon the EMG testing and the nerve conduction studies that can't be faked, and your observations of Mr. Keetley, what is the likelihood that he could fire or maintain control or hold on to a high caliber weapon using his right hand only?
Extremely unlikely.
Is that opinion within a reasonable degree of medical probability?
Yes.
What do you base that opinion on?
The ability to have a coordinated motor skill, and then the diminished grip strength that he has to hold a high caliber weapon and fire it multiple times will be very, very challenging for someone with a hand like that.
Given the condition of Mr. Keetley's right shoulder, his grip strength, the condition of his right hand, would he have been able to hold on to a high caliber weapon without dropping it after repeated shots on November 25th, 2010?
It's unlikely that he would be able to.
And is that opinion within a reasonable degree of medical probability?
Yes.
Are you familiar with a shotgun or a pump-action shotgun?
Yes.
Given the condition of Mr. Keetley's right shoulder and right hand on November 25th, 2010, what would Mr. Keetley's hand positioning have to be in placing a pump-action shotgun into his hand?
Well, it'd have to be placed in his hand, and then it'd have to stay within a reasonable axis in front of his right arm, since he really has limited ability to cross over to his left. So if his left is firing, typically the right hand comes over to the left side to fire a shotgun. So the problem is that he doesn't have the ability to come over because he doesn't have the ability to rotate. So it's it'd be very, very difficult for me to imagine how he would bring his right arm over to then have to stabilize something to fire it with his left arm.
On November 25th, 2010, when Mr. Keetley had been able to pump or slide a rack or a shotgun with his right hand without first having to open or extend his fingers.
It'd be very difficult to.
Can you explain why that would be very difficult?
Well, because racking a gun or racking a shotgun is a two-handed event where you have to stabilize the weapon with one hand and rack it with the other. And you actually have to be able to grab something to rack it, and it's actually a hard thing to do. It takes a lot of strength and coordination.
And fair to say Mr. Keetley at that time, given his shoulder and the condition of his hands, didn't have that strength or coordination?
Objection, lady.
Did Mr. Keetley have that strength or coordination back in November of 2010 based upon your review of the records, your observations of him, and based upon the testing?
Not with his right hand.
Additionally, would his thumb have been moved out of the way?
Yes, at the same time, yes.
Okay. And can you show the ladies and gentlemen of the jury why the positioning of his thumb and why his thumb would have to be moved out of the way?
So if you place something in, the thumb is still going to be close to the palm. So the most important thing in thumb extension and thumb abduction is that the thumb comes out so then you can hold something. So it's almost like a two-step process where you bring your hands out and then you bring your thumb out. It's not all together. You almost have to have something like this to kind of open both together to grab onto it. It's not going to be easy to do.
Did you need to physically observe Mr. Keetley on November 25th to be able to render an opinion today about what he would be able to do or not do on that date?
No, because the electrical studies don't lie. Even though the last time I saw him was in August, the electrical studies tell a story of nerve palsy, and nerve palsy that's unchanged since the last time I saw him.
Did you happen to review, I believe it was Defense Exhibit 18? Yes, 18. I want to make sure I get the right number. The primary care physician, a couple of notes of Dr. Barossi.
Yes.
And I just wanted to go over those briefly. Now you're a doctor. Are you able to decipher this? I don't have my Captain Crunch decoder ring with me today, so I'm hoping you can help us.
This is Med School 102.
Okay, 102. Okay. What is SOAP?
So SOAP is a very basic type of note. It stands for Subjective Objective Assessment Plan.
Okay. I think we can see that, the capital SOAP.
So S is like, I'm complaining of pain, or it hurts, or I can't do this, or I can't. So it's the patient's statement. What's wrong? What's he complaining about? That's the patient's subjective. The objective is your objective physical findings, your exam, the vital signs, all that stuff, the facts of like your exam. Then the assessment is like, what do I think this is? And then the plan is, what are we going to do about it?
So the subjective is there's Mr. Keetley's having some pain, having some issues with his right arm, and he's talking about some radial nerve issues. Is that fair?
I'll try my best here.
Yeah.
Patient's a 40-year-old white male complaining of nerve pain. That's the first sentence. Right arm for over 10 to 11, I think, months. Patient's had right arm gunshot wound, which led to, I can't
Damage.
read that, damage of the radial nerve. Patient's hand been in on meds for nerve pain, and now I am not getting his meds.
Okay.
Patient's also complaining of persistent
We can,
headache.
yeah. Let's go to the O.
The O, right arm is a vertical scar with
That limited range of motion.
limited range of motion. Yes, thank you, very good. Palm closed and won't open on his own. No rash on or infections.
And under the assessment, does the doctor note that there's right arm partial
paralysis.
Okay,
Yes.
and so is that consistent with your own diagnosis of Mr. Keetley with right arm paralysis?
Yes, it is.
Based upon this note, has there been any change, what you've seen in Mr. Keetley's ability to independently open or extend his right fingers or right thumb from when you saw him back in August of 2010?
It doesn't seem to be, but I wasn't here for this exam, so it's not really going into great detail, but it sounds the same.
One moment, Your Honor. Dr. Halpern, do you see Michael Keetley in the courtroom today?
Yes.
Could you please point to him and identify a piece of clothing?
Sure, he's got a light blue shirt on and what seems to be a brown sweater or jacket.
Your Honor, can the record reflect that Dr. Halpern's identified Mr. Keetley?
Just a reflect.
Thank you. No more questions at this time, Your Honor.
Cross-examination? Yes.
so Dr. Halpern, you don't have a personal relationship with Michael Keetley, do you?
No,
You didn't see him outside of a clinical setting, hospital, your office, anything like that.
no.
So how he would have conducted himself when he's around his friends, he's at home, you can't necessarily speak to.
That's correct.
So let's go back to you and defense counsel talked a lot about extension of the hand and of the arm. I want to talk about flexion. Is there a difference between the two?
Night and day.
So tell me about that.
So flexion is controlled by the flexor or the other side of the arm. It's innervated. Most flexion muscles are innervated by the different nerves on the radial nerve, such as the median and the ulnar nerves.
Okay, so we've got 3 nerves in the arm, right?
3 major nerves in the arm.
Radial nerve is the only one in the right arm of Michael Keetley that was damaged.
That's correct.
So when we're talking about the other 2 nerves, those 2 nerves control flexion, closing of the hand.
That's correct.
So those nerves were not damaged by that gunshot wound.
That's correct.
So when you're seeing Michael Keetley as a patient, the only nerve that you see that's got palsy, paralysis, damage is the radial nerve.
That's correct.
In terms of his ability to flex and close his hand, right hand specifically, he has that ability.
Absolutely.
Now, you had talked on direct about the passive extension of his hand. If his hand, with other hands, some other object, is opened, he has the ability to then close it with force.
Yes.
It's not a passive closing. It can be a forceful closing.
Absolutely. And that was shown on his grip strength analysis.
We're going to get to that, and then also you were shown this still from the Channel 10 video, that apparatus that he can use to squeeze and work on his mobility.
Sure.
Okay, you know what I'm talking about?
Yes, I do.
Okay, we'll get to that in a few minutes because you're going to give me the right terms for it. All right, first let's talk about the surgeries that you did. There's a difference, and I'm going to be somewhat sarcastic about it, in the surgeries done to the right side of his body and to the left side of his body.
100% different.
Okay, left hand surgery. That was in what, February and June?
There were 3 surgeries. So the one that it was original injury, where we debrided that and stabilized his bone in January.
Okay.
Then in March, we did the bone graft with the Tina Glide. And
Let me stop you. I want to talk about the left hand right now.
Yeah, left hand.
Okay, so go ahead. So left hand, what are your surgeries?
Left hand had 3 surgeries. The
Yep.
original debridement, then the bone graft with the fixation, and then the third one was the capsulotomy and the tenolysis.
Bottom line, after you finish those surgeries, you're happy with the results.
Very.
Mr. Keetley's happy with the results.
Yeah.
He has a fully functioning left hand.
So his hand is fully functioning. His motion is pretty much 100%. He still doesn't have probably 100% of the strength, but he has good strength. At 90 pounds, that's a good strength.
So when you did that grip strength test, what I want to talk about left hand right now, 91 pounds, right?
Correct.
Grip strength, left hand, fully functioning in terms of mobility, movement, flexion, and extension.
Correct.
So when we're talking about his left hand, after that final third surgery to his left hand, you've got a patient who has a fully functioning, fully usable left hand.
That is correct.
Let's talk about his range of motion on his left arm. That's fully functioning, correct?
That is correct.
Can go forward and all the way up to 180 degrees,
Yes.
out all the way,
All the way.
and then in terms of putting his arm behind his back or internal rotation, you've got a fully functioning left arm to this patient.
Left upper extremity function.
Okay. So now, let's talk about, is it the March 10th tendon surgery, the babysitter surgery?
Okay.
All right? That surgery was to give the defendant the ability to supinate, rotate his hand outward, right?
No.
So tell me about that.
So the pronator muscle is the muscle that actually takes the arm from neutral and pronates it palm down. So actually taking one of the 2 major pronators of the forearm and moving it to the back side of the forearm, and we're actually attaching it to the distal end of the tendon where his extensor carpi radialis brevis, which the muscle is in the extensor mobile wad in the proximal form, attaches to the base of the metacarpals of the hand. So the function of the ECRB, extensor carpi radialis brevis muscle, is to extend the wrist.
So let me stop you right there for a second. So he still has the ability to turn that hand, his right hand now, outward.
Absolutely, that's supination.
Okay, so when we're talking about that babysitter tendon surgery, he still has the ability to rotate his hand from this neutral position that you called it outward so that he would be thumb facing up.
So the function of supination is from the supinator and also from the brachioradialis. So the supinator is not radially innervated, and the brachioradialis is a musculocutaneous nerve, which is not radially innervated either. So both of these are responsible for supination of the forearm.
With that surgery, you're now taking his wrist from a more flexed position to a more extended position.
Actually, probably more neutral position would be a better term.
And I probably was doing that with my hand, but not saying it correctly. So we're taking him to where his wrist is going to be flat with his forearm.
Correct, at least collinear.
Still, no extension.
Yeah, so he's not going to be able to hyperextend like, I didn't make him so tight where he was way up like this, because that would get in the way of some other things. So,
Life.
yeah, so when we say babysitter, it's because we're not actually cutting a tendon to attach the motor, the new muscle to it. We're actually kind of like, I'm trying to describe how we weave it through the tendon. We actually make a hole and we put it through, and then we sew it back and forth. So we're not cutting that tendon, we're actually weaving it through it.
So you're giving the existing tendons a helper.
Correct.
Okay, so with that helper, he now is taken to a more neutral position.
That's correct.
Still able to make a fist, close his fingers, flex with force.
So when you did that, you were a little misleading. I'm just going to make sure we
That's
understand that he's like this, and he can still hold. He still can hold things that are placed. He can't go like this and this. His wrist is collinear now, and he can grab onto things, yes.
So let me steal my Coke out of the water bottle. If I take this water bottle, the defendant cannot independently open, if his hand's closed.
Because what you just did is you open your fingers to
Right.
grab onto that, right? You saw that, right?
Yep, and so he cannot open his fingers to grab that. But if the water bottle is taken and fingers are moved out of the way and placed into his hand, he can hold it.
Yes.
He can continue to grip it.
Yes.
He can hold it between thumb and all of his fingers in a flexed, gripped position.
Yes, he can.
And he actually has the grip strength in that right hand, although decreased, to hold something if it's placed there.
He does. He does. It's not strong. It's about half of what it normally would be. So,
So when we're talking about that 70-pound to 140-pound grip strength range, that's still maybe not what an adult male at his age would have for grip strength, but he can pick things up.
absolutely, yes.
He can hold things.
He can hold things, yes.
Gallon of milk, if it's placed into the hand by the handle, he can still hold that.
He should be able to hold that, yeah.
Okay, so when we're talking about items that are heavier, he's limited on that top end, but still has that grip strength to hold something once placed in that right hand.
That's correct.
Okay, before we move on from this right arm, I want to talk about right shoulder range of motion.
Go ahead.
You can use the terms, I'll do the motions. When his arm's going out away from his side, adduction,
Abduction, abduction.
okay, abduction, full range of motion. Up in
Yes.
front of him, full range of motion.
Yes.
Coming in to his side, full range of motion.
Adduction, yes, full.
External rotation, practically full range of motion.
About 50%. He was at 45 degrees of external rotation.
And that's getting pretty far into external rotation.
Well, that's halfway where you're just showing right now.
to
No,
right about,
that's 90 degrees. You're almost, yeah, no, that's, so if you want to come here, I'll show you where he
All right.
was. So this is the neutral position of the hand right here. So 90 degrees would be this, 45 degrees is here.
okay, so we're talking about 45 degrees of external rotation,
Correct.
20 on internal rotation.
20.
Okay, so we're at 20 degrees.
That's 45 right there. So 20 is halfway, yeah, you're about right there. That's about it.
Now, this external and internal rotation is only taking into consideration essentially the arm, elbow, hand, and its movement, right?
Well, it's the whole upper extremity. So this is a complex motion now,
Sure.
okay? So when you isolate internal rotation, you are actually keeping the elbow at your side, and you're actually asking the patient either to do this or to bring out. That's how you measure internal external rotation. No one. You can measure it like this too. It's another way of measuring it, okay? But most therapists measure it with the arm at the side.
So when you've got your arm right at your side, you're not taking into consideration movement of the torso, movement of the shoulders, or the upper back. So if we're talking about an internal rotation, that's not taking into consideration if I move my upper body.
That's correct.
So when we're talking about that 20-degree and limited range of motion, that's looking at an isolated circumstance, but not taking into consideration that there's adaptations.
There can be adaptations.
And that moving the entire body can be an adaptation to assist with a limited range of motion on a specific part of the body.
I agree with you.
In one of your medical records, and I'm not going to go back through them with you, you refer to Mr. Keetley as being, quote, highly motivated in his recovery. Highly motivated, the words that you used. Do you recall that?
Absolutely, yes I do.
You would agree that he was motivated to recover to the fullest extent possible.
I agree with that.
In your practice, patients who are motivated, who are willing to put in the work, see greater results than patients who may not follow through with treatment plans or physical therapy.
That's a good statement. I think the best way I could probably give you an analogy is a study that was done in flexor tendons. So flexor tendons are very difficult because there's a lot of motion, a lot of therapy, and obviously the more motivated, you're right, probably they do better. The best study in flexor tendon recovery was in the Navy. Why? Because when those Navy physicians or Navy personnel had to go to therapy, if they didn't go to therapy, they were court-martialed. Guess what? They never missed therapy, okay? Because otherwise they ended up in jail. So they had tremendous motivation to do the therapy. You could not even, no one in the outside world could equal that study, their results. Okay, we tried. No one does it. But he did very well. He attended 50 therapy visits.
And those 50 therapy visits, and what you're going to is motivation impacts ability to recover.
I agree with that.
Mindset would also impact ability to recover.
Yes.
If someone's willing themselves to work as hard as they can, they're going to see greater results on that.
I hope all my patients have that.
That mindset and that motivation can also extend beyond just completing a physical therapy session, but can go even as far as learning adaptations and modifications to day-to-day skills so that the patient's limitations are exceeded because, frankly, they want to.
Well, I grew up with that.
Your dad had a disability, right?
He lost his arm here, high up in his shoulder level.
And he was pretty capable.
If you told him he couldn't do something, he did it,
And that's where his motivation kicked in, right?
basically.
All right, so with your dad's limitations, he still learned how to overcome a lot of that, right?
He overcome what he could.
There are still some limitations, sure,
Absolutely.
but modifications are where that kicks in.
Can.
And learning how to, if you have that limited rotation in your arm, moving your body so that you can reach, grab, pick up things.
It makes it more difficult, certainly, but it can be adapted, sure.
Not impossible.
No.
Okay, so let's talk about that hand contraption thing that I don't know the name to. I'm going to have you give me the specific medical terms and things like that. But when we're talking about that hand apparatus, fair to say that the defendant's hand has to be placed into it.
Correct.
But once there, the flexion, the ability to bend the fingers exists.
Absolutely. That's exactly what it shows.
Now, when we're looking at that, the fingers are extended because that spring's recoiling.
That's correct. That gives the force to straighten them back out.
So if his fingers are straightened back out, he can rebend.
Yes.
And that's exactly what that spring device was doing.
So the idea is that, the fingers have no muscles in them, okay? The fingers are just basically skin, bone, tendon, joint. That's it. The muscles that power the fingers are in the hand and the forearm. So basically they're an extension of what we call a muscle, tendon, bone unit. So anything that, and there's nothing to change that relationship of the flexion apparatus of Mr. Keetley. So that's all intact. So if you position him in the proper way, he has the ability to shorten that
By flexing his fingers.
by flexing his fingers.
Now, When he's flexing his fingers, is that something that's unique to that device that you saw the screenshot of?
Well, yeah, that it was designed to allow someone that has heel nerve palsy to flex.
So what if there was another device, apparatus, object against his hand that recoiled back, would he, and extended his fingers, would he be able to squeeze against that, flex against that again?
He'd be able to pull against it, sure, absolutely.
All right, on direct, you were asked a lot of questions that were very specific to single hand positioning of a firearm. You know what I'm talking about?
Yes.
If the defendant has a high caliber weapon, firearm, in his right hand alone, can he fire repeated shots from that firearm?
He probably could, but it'd be very difficult to control at a certain point. He doesn't.
Okay.
It takes a coordinated motion to hold on to a firearm like that. There's a lot of force going on and a lot of torque, and it's
Kickback, recoil.
Kickback, recoil.
Sure.
It's just
You shoot guns, don't you?
yeah.
Pistols,
Yes.
shotguns,
Yes.
target practice,
Yes.
skeet shooting.
Yes.
Okay, I want to talk about semi-automatic pistols for a second.
Okay.
When you fire a semi-automatic pistol, single-handed or do you use two hands?
I actually use two hands, believe it or not. I actually use my second hand to support my dominant hand.
Goes underneath your dominant hand.
That's correct.
Now, by placing your non-dominant, so are you right-handed or left-handed?
I'm right-handed.
Okay, right hand's on the firearm,
Correct.
right?
Yep.
Non-dominant left hand goes underneath your right hand,
Yes.
underneath the butt of the magazine.
Yes.
What's the purpose of putting that non-dominant left hand underneath your dominant right hand in the gun?
It stabilizes the gun.
Does that give you some ability with your left hand to also control the movement and the weight of that firearm?
Of course. Yes.
By doing that, you've got the ability, if you needed to control the weight and the stability of that gun almost exclusively with your left hand to now free up your right hand to just pull the trigger.
It's conceivable, but the problem is that his right thumb is the real problem. This is the problem I have with that, is that the thumb he cannot move his thumb out of the way of the recoil of the barrel of a semi-automatic pistol,
The slide?
the slide. And so
Okay.
a lot of people that fire would know that if you don't have your thumb out of the way, that's one heck of a whammy that you get from that pistol. Because the barrel action will come back and hit that thumb.
So when we're talking about, and we'll get to that in a few minutes, but just talking about the stability of using two hands, does that change your opinion on his ability, take and set his thumb aside for a second, I hear what you're saying on that. Does that give him the ability to stabilize and now shoot right-handed if he's using two hands instead of a single hand?
It helps him a lot.
Okay, so now, let's go to rifles. You were asked previously if a rifle that was in evidence, and I can show it to you if you need me to, a rifle that was in evidence is a firearm the defendant would be able to shoot. Do you recall?
Yes.
Right. Is the defendant able to, with his limitations, shoot that rifle?
I think that if he has time to place it and it's already preloaded, in other words, he's already somehow, readied that to be fired. He doesn't have to cock it or anything. So if he comes up with it's already preloaded, so there's a round in the chamber, and he's placed it, one aspect of that in his right hand to hold on to, and he's firing it with his left hand. Yeah, it's possible. I mean,
All right.
he can do that.
Does the rifle have a shoulder stock?
Yeah, some of those come out with extendable shoulder stocks. Yeah.
All right, so let's not talk about an extendable shoulder stock yet, but a regular standard shoulder stock on a rifle. That's going to sit up against the shoulder,
Yes.
right?
Yeah.
And you're giving me a look because I've got it up against my right shoulder, and the defendant's got injury to that shoulder.
That's right.
But isn't it also possible to lower that and put it between the arm and the side, or directly up against the rib cage for stability? Not ideal, but capable.
Yes, of course.
So if we're using that shoulder stock, maybe in a non-traditional setting, he still would have the ability to increase the stabilization of that firearm.
There are ways to do that, yes.
Now when we're talking about left-hand side, it's fair game over here, right?
It's good.
There's nothing wrong with the left-hand shoulder.
Nothing.
That stock could sit up against the left-hand shoulder easily. Answer out loud for me.
Yes.
Okay. Left hand works fine.
Yes.
So now left shoulder carries the stability for that shoulder stock. Left hand is on the trigger. Right hand can be on the barrel of that rifle.
It'd be a tough one to do though, because for him to reach over and across his body, this is exactly what I was talking about. If he's going to hold it, if he's going to fire and stabilize from the left side, the right arm has to come over. He really has to get that arm over across the mid-axis of his body. And
Unless he brings the firearm this way and takes more of an angled shot.
yeah, it would be a distinctive posture for him to do that.
Sure, distinct, but it's a modification.
Yeah, it would be a definite distinctive modification.
And if you practice that posture, you practice that ability to modify, that's a learned skill set.
He could learn. I mean, he could learn to write with his left hand. He could learn how to shoot with his left hand. I mean, I'm not.
Practice makes perfect.
I can't say that's not possible.
All right. If a firearm, well, let me ask you this way. You're familiar with modification kits for firearms.
I'm somewhat familiar with them.
You've got at least basic understanding.
I have basic understanding. I've never used one. I've never had one or owned one.
Yep,
or
not
operated.
asking you about that, but you know what I'm talking about when I refer to a modification kit.
Yes, of course.
Now, if we've got a modification kit that allows for a shoulder stock, or as you were talking about, an extendable shoulder stock that gives the firearm the ability to have another point of contact, does that create increased stability within that weapon?
Well, those kits are so varied, and I'm just, I'm not going to put myself off as a firearm.
I get it,
expert.
I get it.
That I won't do. I mean, maybe there's someone else in your line that does that.
Sure.
A lot of these kits are very creative. I've seen a couple of them. I'm going to have to say it's possible.
Okay. What if that kit had an additional grip on the front of the weapon? Does that create another stability point for that weapon?
Yes, but when you have a second point, the only thing I want to mention that didn't come out before is that you've got to get his hand out there to do that. You're taking it away from a stabilization point. Then, when you have 2 points, usually those have something that reaches way forward of
Sure.
the pistol itself, because they usually put the pistol in some sort of framework, and then they have a second. What you showed me, it had like a second area to hold on to way in front of that.
So what if that grips further back? And now you're not reaching quite as far forward, but you're closer in. Does that give the firearm the additional stability of up against the shoulder, right hand or left hand on the trigger, and now we've got an additional point of contact? That changes the physiology of the ability to hold that. Would you agree with me?
I just, for me, I'm going to say I'm reticent to say. I could say anything's possible because so many things could be adapted in the world of firearms, and
Yep.
again, I'm not gonna. It's hard for me to comment on that. I'm not sure.
That's fine. I'll back it up a little bit.
Yeah.
If you've got the ability, through whatever form of modification we're going to talk about, to increase the points of contact and the stability of a firearm, does that improve the defendant's options for firing that gun?
Yes, of course. Yes, I think so.
Now, through all the nerve tests that you went through, all of your treatment plan, we're talking about from January of 2010 through the last time you saw the defendant was August of 2010.
That's correct.
You ordered an additional nerve treatment in November.
Nerve test.
Nerve tests in November. Fair to say, from January of 2010 to November of 2010, there was improvement.
Yes, there was.
We're not going to sit here and say it gets all the way down to the forearm.
No.
But from the elbow up, you're getting nerve sensation.
Yeah.
You're getting improvement in nerve function.
Well, so unfortunately, the radial nerve doesn't innervate anything above the elbow. Unfortunately.
Is that going to increase mobility and body awareness with that arm by having the increased nerve sensitivity up to the elbow.
So what showed improvement were the deltoid muscle, which is a shoulder muscle,
Right.
on this part of the upper arm shoulder, and the biceps brachii and triceps. So these were all muscles that were directly injured by the blast and the gunshot itself. Okay, so that when you looked at the nerve test, it showed recovery, at least a very good promise of recovery of those muscles on the nerve test.
So when we're seeing that improvement in the muscles, that also is going to improve essentially body awareness. You now know where your arm is. You've got more control over your arm.
Well, those nerves, again, are motor, not sensory. Okay, so be careful. So the radial nerve doesn't innervate anything below above the elbow. So the nerve that innervates in this area of the arm is the musculocutaneous nerve, which is from the C5, C6 region of the neck. We really didn't look at that nerve, but he would have improved muscle function of the triceps, of the biceps, and the deltoid muscle in the upper arm.
The improvement of those muscles, although maybe not improving what's below the elbow, increases strength.
Not of his hand or arm.
I'm not saying, no, not, and I should have been clear on that. It's not increasing hand or strength in lower portion of arm, but this portion of the arm can be stronger, can be more mobile if you've got greater muscle strength.
Well, because the EMG, all the EMG shows is the innervation and muscle activity going on. So he still was weaker because he had signs of muscle recovery in
Right.
those. He still had signs of muscle denervation in those muscles, but he also had signs of muscle recovery and improved nerve conduction in those nerves. But those don't equate to muscle power yet. And usually there's a delay. So that's why I wanted to get the EMGs. The EMGs are like an early warning radar system. You actually can see improvement in an EMG way before you see the clinical improvement.
Sure.
Okay? So that's the major reason why. I already knew he had a radial nerve palsy. I wasn't getting the test because I wanted to know if he had a radial nerve palsy. I wanted to know if he had electrical signs of early recovery in any
Makes
of those
sense.
muscles.
Okay.
Okay?
So another term I want to talk to you about that you have used previously is bilateral use. Do you know what I'm talking about?
Maybe explain a little more.
Both hands.
Yes.
Ability. So tell me what I'm talking about.
So, having a father with one arm, I can really attest to this. So there's certain things he just could not do with one arm. Okay, like maybe hold something and turn a bolt, or he was a mechanic, so I used to help him do a lot of things. We worked on a lot of cars and airplanes together and motorcycles. So, coordinated effort between hands is a huge functional ability that we have. And so when you don't have it, when you have one hand which is much weaker than the other and has loss of function, it can hamper you quite a bit in some complex tasks.
And when we're talking about maybe not even complex tasks, but day-to-day tasks, there is the ability to learn, relearn at least a portion of that coordination. Maybe not up to 100%, but get you to a point where you can function with day-to-day tasks.
I didn't, maybe in the therapy notes there's some, but there are some tests that they do for coordinated hand motion and function, and it really was diminished. Like, for instance, for him to button, a button or a sweater, be very, very difficult. That's a very fine, motor task that involves a lot of different things with your hands. And
But
fingers.
different than the motor task of taking a larger object and placing it into the hand and closing the hand around it.
Absolutely. So the simpler the task, the more likely, the more combined or complex the task, the more unlikely.
Sure.
There's no absolute yes or absolute no, unfortunately.
Okay, so something you were talking about on direct examination was racking a firearm.
Correct.
Charging that slide on that firearm.
Yes.
Now, when someone's typically racking or charging that slide on a firearm, they're going to hold it in their dominant hand, grab the top of that slide, rack it back or slide it back, and now the firearm's ready to be used, right?
Everyone has their own way. If you ask every officer in this building, I guarantee they have different ways of racking their weapon.
Sure. One of those ways, if you have a shoulder stock, is you can hold that gun and use your shoulder stock as the backside to give you leverage so you can rack that slide more easily.
That's true.
Another way you could do it, if it's a long gun, is put the barrel down to the ground and push into it and then rack that slide that way.
There are ways to learn how to do this, obviously.
And this is a modification or an adaptation that someone with physical limitations can learn to work around if they're motivated enough.
I agree with that.
Dr. Barosi's notes that I can't read. You were not the treating physician at that point.
Well, I take heart to that. I'm very attached to my patients, so
Sure.
it's like I'm married to them. Once I operate on them, I feel like they're always mine.
Okay,
He wasn't under my care at that time.
that's probably the medical way of saying it then.
That's the best way to say it.
You were not actively following up with him, seeing him. He wasn't under your care
At that time.
at that time. So when we're looking at Dr. Barosi's notes and writings, do you know whether the defendant was following through with use of braces or treatment or physical therapy as you were aware when he was under your care?
That's interesting you say that, because I think, and I remember this, and there may be a connotation in my chart if I can look at it for a second. I don't think he had access to a couple things after that time frame. He didn't have
Sure.
access to like medicine, like you saw. He didn't have access to splints or
So
anything like that.
lack of access to those apparatuses, medication, does that present the ability for, you're going to use the medical term, I don't know what it would be, but deterioration, loss of improvement?
Absolutely.
So when we're seeing medical notes that are saying that the skin in his palm is dead and his hand is closed up, does that mean that that's how his hand was when you saw him in November?
No. So let me explain why that description came about.
Yep.
So people that have this type of palsy are prone to getting contractures and getting what we call like hand and palm deformity. So if they don't have regular braces and don't have regular therapy or don't have or don't do what they're supposed to do, the balance is way off to start with. The flexors are always stronger than the extensors. Now you've taken the extensors out of the equation, and over time, it just will contract down into his palm. And then what happens is then the skin gets all macerated because it's never able to dry. That's why the maceration occurs.
So the deterioration of the skin, the closing up of the hand, that's not how you saw him in November. That can be, go ahead, sorry.
Well, I didn't see him in November, so.
In August, sorry. In August, that's not what his condition looked like.
Correct.
When you're looking at Dr. Barosi's notes, those are based on what's available at that time, and you're only going off of his notes, not from what his actual care would have been.
Correct. So the EMG was done on I believe the beginning of November, and then a month later, I believe that was Dr. Barosi's notes. So a month after the EMG.
Okay. You have a moment, Your Honor?
Yes.
Pass the witness.
Redirect.
Whether he had splints, he didn't have splints, whether he had some dead skin, he didn't have some dead skin, does that have anything to do with radial nerve palsy and his inability to actively extend his fingers and thumbs on November 25th, 2010?
No, it would not.
You were talking about his right thumb, and I think you were talking about the slide, and I have no idea about guns. And the shooting back, can you explain that again? Because I really wasn't following that along. Because of the positioning of his thumb, if a shot is fired, I think you said his thumb would be in the way?
It would get crushed by the action of the semi-automatic pistol. So a lot of beginners, they leave their thumb, in the way of the slide, and it just knocks the skin off or it bashes the hell out of them, and they'll never forget it. So he does not have the ability to move his thumb. He can't move it out of the way. Okay, and especially if he's holding. Usually when you support your other hand, it's usually from the bottom, and you can't control where the thumb is, even with your other hand. Especially if you're holding the other hand while you're holding a firearm. This hand is down here. It's not like up here holding the thumb away. It's underneath. So my issue with supporting the hand is it does nothing to move the thumb out of the way of the action of the semi-automatic pistol.
Right, so if he had his holding of his hand, he cannot actively and demonstrating move his thumb from one way out of the way. His thumb would have to stay there and take that bashing.
It would be brutal.
Nothing further, thank you.
May this witness be released by the defense
Yes, Your Honor.
and by the state?
Yes, Your Honor.
Doctor, thank you. You may step down. You may be released as a witness at this time.
Thank
I
you.
need the attorneys to approach. Actually, well, no. Mr. Escobar? No. Well, all right, approach. Proceed and do that. You a minute?
Yes, we do, Judge. Should we approach real quick?
Yes, you can. We're going to take a relatively short break. I'm still going to get you out of here before 5 o'clock today. But do not discuss the case amongst yourselves or with anyone else. Do not do any research related to the case and avoid any exposure to the case outside the courtroom. All rise for the jury. Thanks again, everyone may be seated. And the door is closed. Thank you, Christina. It would have been fixable, but thank you for reminding me before I allow the defense to rest.
Yes, sir.
Mr. Escobar, are you ready for me to do the colloquy with Mr. Keetley regarding...
Absolutely, we're looking for one more example.
While you do that, I'm going to go ahead. Mr. Keetley, you can remain seated. Okay. I do have to swear you in, though, because I have some important questions to ask you. So if you'll raise your right hand, please. Do you swear any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, sir. So I mentioned to you yesterday that towards the end of your case, at some point, I would be asking you some questions about your decision whether to testify in your case or not. And remember, I said that is your decision and your decision alone. However, I do suggest that you talk to your attorneys and get their advice about that decision before you make it. So my first question to you, Mr. Keetley, is have you had sufficient time to talk to your attorneys about your decision whether to testify or not testify?
Yes, sir.
And do you understand that you have an absolute right, if you wish, to testify? You'll come down here, I'll swear you in, just like any other witness. You'll take this witness stand, and they'll have the opportunity, your attorneys first, to ask you questions, and then the state would have the opportunity to cross-examine you. I always mention, I don't remember in this case, and I actually don't think you have any prior felonies, but I always mention that if you do decide to testify, and you do have any prior felonies, which the state has certified copies of the convictions, that is something that would most likely come out and the jury would hear during your testimony. Do you understand that?
I understand.
And let me just ask, is there any certified copies that you have?
Judge, I don't believe so.
Yeah, I didn't think so.
I didn't
All right.
think there's any.
All right. So that is not something that would come out if you decided to testify. They would not be able to bring out that you had any prior convictions for felonies or misdemeanors involving dishonesty or false statement. Do you realize that?
Yes, sir.
All right. So you also have the right to not testify. And in fact, if you choose not to testify, there is an instruction that I read to the jury that tells them that should have no effect on them. They are not to hold that against you in any way or take that as any evidence of your guilt. Do you understand that?
Yes, sir.
All right. Do you have any questions of me?
No, sir.
Have you made a decision?
Yes, sir, I have.
What is that decision?
I'm not going to testify.
Has anyone forced you or threatened you in any way to make this decision?
No, absolutely not.
Are you under the influence of any drugs, alcohol, or prescription medication, or any medication of any kind that might affect your ability to freely and voluntarily make this decision at this time?
No, sir.
All right. Thank you very much. I appreciate that. Let me just ask, I always do, any of the attorneys wish me or wish to ask any additional questions of Mr. Keetley regarding his decision not to testify from the defense?
Judge, if I may answer, the answer is no, sir. And I will tell you that I have had
I
a lot of
appreciate it.
conversations with him at the jail. We have talked about this extensively, as has his prior counsel, Ms. Gowdy, now Judge Gowdy.
All right. And yes, this is a rare occasion that this is a second trial. That doesn't happen that often, but Mr. Keetley made the same decision in the first trial. So I appreciate you putting all of that on the record. Did the state have anything additional that you wish me to ask?
No, Your Honor.
All right. All right. I'm satisfied with your answers and your decision not to testify. So I believe what that means is the defense has one additional exhibit to introduce.
Judge, if I can address this, and if I can approach the bench, just
Yeah.
showing you my computer. Here, I've shown this to Ms. Doherty. What you're looking at is the jail sheet for Michael Keetley, his booking sheet. Unfortunately,
Is that from the time?
so here, yes and no. Yes, in the sense that he was originally booked in, but when the additional charge from the jail took place,
They took another
a
picture.
picture. We have his booking photo. What we want the jury to know is that he is at the time of his arrest, he was 5'11" and weighed 212 pounds. I believe the state is willing to stipulate to that. What I'll do is I can draft that formally for tomorrow morning, but if you're good, if you just read that the state and the defense agree as fact, at the time of his arrest on, I want to say December 2, 2010, Michael Keetley is 5'11" and 212 pounds, and then we're
And you're sure that's not what's reflected there? That's what was reflected on the original booking?
Correct. If you look, his original receipt in jail
Well,
still
it's-
shows 12/2.
So the only thing they updated was the photograph, but not the
Correct.
height and weight.
Correct, and the hair is misleading now because there is a little bit of a different color because he's been
A lot
in
of time.
for a long time. So that's what
I'm perfectly fine with that, and however you want to do it. If you want to draft up, are you suggesting you draft up a formal stipulation? I read the stipulation instruction and then read the stipulation to them, including those height and weight facts.
What I can do, if the court wants, is I can quickly type something or write something that's agreeable, and then overnight we'll file that we'll have the stipulation filed for tomorrow morning, if that works.
Yeah, and you just want me to read it to them? You're all right with me
Yes.
reading it to them tomorrow?
We want it, I want it today. I bring them in, because we'd like to rest
Okay.
in front of the jury. Have you read stipulation? Then we will.
All right. Type up what you want me to read to them. Show it to them. I've got the stipulation instruction. I can read it, and then we can file the formal.
Yes, I'm sorry. Ms. Doherty was talking to me, and she, for the record, just confirmed the original CRA does also confirm that height.
That height and weight?
Yes, sir.
Okay.
Yeah.
I am going to tell them to come back at 8:30 tomorrow. Because I'm going to read instructions, and then we'll do closings, and get them deliberating as early as possible tomorrow. Yes, we're ready.
All right, jurors entering.
Jury is presently seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. Did anyone discuss anything about the case, or was anyone exposed to anything about the case during the last break by show of hands? Let the record reflect there are no hands. Again, thank you all very much. I'll ask the defense if you're ready to proceed.
Yes, sir, we are. At this time, we would ask the court to publish defense exhibit number 41 to the jury.
All right, ladies and gentlemen, this is a stipulation. I am going to read you the stipulation instruction again, and then I will read you the actual stipulation. When lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is, and it is this document that I will read to you. It is titled Stipulation, and it says, "It is hereby stipulated by and between the state of Florida and the defense that the following facts are true and correct. Michael Keetley was arrested on December 2nd, 2010. At the time of his arrest, he was 5 feet 11 inches tall, and he weighed 212 pounds. We hereby certify that the foregoing stipulation is made in good faith and for the reasons herein alleged, dated this 23rd day of March 2023. It is signed by Michael Keetley, the defendant, John Grant as attorney for the defendant, and Michelle Doherty as assistant state attorney. And handing it to the clerk, and it is in evidence now as Defense Exhibit 41. Thank you. Is the defense ready to proceed at this time?
Yes, sir, we are. At this time, we announce that our case is complete and we rest our case.
Ladies and gentlemen, the state having rested their case and now the defense having rested their case, you may recall from the initial instructions that the next step is the closing arguments. We are not going to do those tonight for a couple of reasons. One, because I have to finalize the instructions, that I cannot do that with the attorneys until both sides have rested to determine and the law that I will be reading to you before the the final instructions. So we're going to do, I'm going to stay here and work with the attorneys to finalize the instructions. I'm going to send you home now. I'm going to ask you to come back at 8:30 tomorrow morning, where we will begin with instructions, and then we will have the closing arguments. Did you have a question? No. Oh, I'm sorry. I thought you raised your hand. Not a problem. All right. So, as I said, we're going to be hearing the closing arguments tomorrow. I suspect that you will be going out to begin deliberations around lunchtime. We will order lunch for you tomorrow, so those of you who may be worried about lunch, bringing your lunch, whatever, we will order lunch for you tomorrow. So please do not discuss the case amongst yourselves or anyone else. Please do not do any research related to the case, and avoid any reports of the case outside of the courtroom. Let me mention this. There is no time limits on your deliberations. No one has any idea exactly what time you will begin to deliberate. I suspect that it will be around mid-afternoon tomorrow, around lunchtime, perhaps a little after lunchtime. If that's the case, we may take a break for lunch before you deliberate. But anyway, I suspect you'll be deliberating in the early afternoon tomorrow. As I said, there is no time limit, so be prepared, if necessary, to go late tomorrow. I am willing to go as late as the jury wishes to go, if necessary. If at some point the jury decides that they would like to go home and come back, we will then discuss whether you will be coming back on Saturday or Monday. I will leave it up to you, whichever is better for the group as a whole. We can do either. I just have to make some arrangements if we're going to do it on Saturday, and I'll be prepared to make those arrangements if necessary. But I just want to let you know that there are no time limits on your deliberations. So with that said, I am going to send you home for the evening. Have a safe trip home. We'll see you back in the morning at 8:30. All rise for the jury. Jury is active. Everyone may be seated. All right. As I said, we've got about 45 minutes at most. Let's start with the instructions, not including the special requested instructions from the defense, because that may take not too long, but it may take longer. I'd like to go through the 23-page stack of instructions that I believe are the same as the instructions that were given last time. Is that correct?
They're all the same except for the verdict form.
The verdict form, and you should have added the Spanish language.
I sent it to Your Honor to add in.
I have it on the top. Okay, and we'll add it in wherever.
I'm going to need to be sent a whole clean copy
Once we, yeah. So, Ms. Johnson, if you'll make whatever changes, because that changes the numbering when we insert it.
Yes, Your Honor.
All right, so I'll make you in charge of making sure that once we go through the conference today, you make whatever changes and send them so that I have a copy to read tomorrow. Defense have the 23-page proposed instructions? Mr. Grant.
Excuse me. Yes, I do. Pulling it up now, sorry. I know there was a separate email that Ms. Johnson sent in relation to the Spanish.
Yeah, I'm just holding that on the side right now.
Okay.
And what I'll tell you to do is as we go through, we're going to go through each instruction and see if there's any objection or if you're in agreement. But when we get to the point where you would like 2.13 inserted, you let me know, and I'm probably going to defer to you and let you put it wherever you want.
Is it 2.13, Judge, or 2.12?
12, I'm sorry. I don't have my glasses on. Maybe I should put them on. It's off to the side. It's not right in front. It's not right up where I can read it. My bad.
You may have just one moment. I'm being abandoned, I think.
Uh-oh, yeah, your whole team is leaving.
Now the real fun can start. No one's watching what I do.
Not even the TV.
Okay, I'm fine to be abandoned now.
All right. So page 1 of 23, jury instructions starts with 3.1, introduction to final instructions.
No objection.
3.2, statement of charge.
No objection.
Do you want to hear from the state too, or you only are hearing from the defense?
Well, I suspect that you proposed them, but it doesn't matter for the record. If you want to say agree, I'll allow you to do that.
And Judge, I don't know.
I definitely want to hear from you if you have an issue with them.
I don't know what the court wants to do as far as capitalization, or if the court has a preference on that. Some judges are very particular on that.
I
Murder
don't
in the
care.
first degree is not capital. I don't care either. Although I will say I just want to make sure it's consistent, which my review of the jury instructions do seem to indicate a consistency there. So,
All right. And if at any time there's something that you do care about, this
Yes.
is the time to let us know. And as I said, if it's a minor thing, I'm probably going to defer.
And we'll put a space in between the 3.1 intro and the start of the paragraph, because it looks like
Yeah,
every
it
other
doesn't.
one does
Yes,
have spaces,
yes.
so I'll fix that, Judge.
Yes, thank you.
and I'll just say, by the way, when we get to, you get to 7.1, and I'll point out my issue of capitalization there.
Okay.
So I'm good.
So 3.2 was good?
Yes, sir.
And the state as well?
Yes, Your Honor.
All right. 7.1 is introduction to homicide, and then it has in parentheses applies to counts 1 and 2. I don't read titles like introduction to homicide, but I would read what's in the parentheses that this instruction applies to counts 1 and 2. I see something on here that I've really never seen before. It looks like I probably should read the victim in count 1 is Sergio Guitron, and the victim in count 2 is Juan Guitron. And am I pronouncing it correctly?
I understand it's Guitron.
Guitron? Guitron.
Yes.
Okay.
So I noticed that too. It's been a while since I've tried a case with 2 counts, same but different victims. I haven't seen it done this way before, but I'll defer to the court.
That is how you read it the last time, Your Honor.
Yeah, and I mean, it usually just depends on the I've done it multiple ways. I don't not like it. Actually, I think that it might.
You would have to read it twice, the same exact thing, just with...
Right, I like it better this way.
Yeah.
I don't have to do it twice.
No, that's fine. It's just a question of, quite frankly, for...
The elements are the same, it's just the name of the victim.
It's the name of the victim is different, I agree. I just don't know how it flows, because I will tell you, when I was reading it and skimming down, I was like, why were you saying the victim? Then I had to go back up. So if you wanted to say, this applies for 2 victims, however you do that, that's fine, either before or right after. I don't
Yeah,
care.
well, I would do it in the beginning. This applies to counts 1 and 2, both victims. The victim in count 1 is Sergio Guitron. The victim in count 2 is Juan Guitron. So then that would, I think, explain then where then in the paragraphs, subsequent paragraphs, it says victim.
Correct, sure.
All right. So under 7.1, introduction to homicide, it includes paragraphs for justifiable homicide, excusable homicide.
I don't think that's an issue in this case, but it's part of the standard, so I just say leave it in.
All right. State is good too?
Yes, Your Honor, I apologize.
No problem. Then I have on page 2, 7.2, murder first degree. Same, this applies to counts 1 and 2. Victim in count 1 is Sergio Vitron. Victim in count 2 is Juan Vitron. And then it has the elements of first degree premeditated murder.
So this is where I would suggest perhaps where you see in 7.2, to prove the crime of first degree premeditated murder, the state's proposal has first degree premeditated, all capitalized. For consistency, maybe we can go back where it's murder in the first degree, capitalizing the first and the degree. And anytime we have murder in the first degree, capitalize the first words that are the primary: murder, first degree, murder, second degree. It's a minor thing. It's just
I don't know. Ms. Johnson, do you have that?
So rather than the dash, you want in the.
no. What I was saying back here. See how it's murder in the first degree? I was just suggesting capitalizing murder first degree.
Do you want then second degree?
Sure. Yeah.
You want all that capitalized?
Yeah, not in the.
But,
And where are you? I don't see that. Where on page 2 is that?
Yeah, approach.
Yeah.
It's on page 1. I'll show you what I was doing. It's a simple. Where you see, in this case, he's accused of murder in the first degree. That's all lowercase.
Right, I see that.
I'm used to seeing murder, M capitalized, first, in degree capitalized. In the prepositions are usually not.
Kind of like it is here.
Correct.
Okay.
That's why we're just
Okay.
saying for consistency.
Yeah. All right, Ms. Johnson, you all right doing that?
yes, Judge, I'll just ask Mr. Grant to make sure he looks at it, because it's a lot of places it's gonna have to be fixed. A lot.
Well, email it to him tonight, and that's what he can do tonight.
I may be able to help out on that, but it's a simple control agent.
All right. So, and I don't mind those changes, but I'm most concerned right now about the
Substantive, yeah.
substance. Yeah. So, 7.2. Defense was all right.
Yes, sir.
State's all right.
Yes, Your Honor.
All right, turning to page 3, 3.4, when there are lesser included crimes or attempts.
Yes, the lessers are correct. I
Okay.
think it's just manslaughter in the second degree. Right?
The lesser included crimes for definition of
There
1
are
and 2 are second degree murder and manslaughter, and then the lesser for attempted first degree murder in counts 3, 4, 5, and 6 are second degree murder and attempted manslaughter.
right.
Attempted second degree murder and attempted
Right.
manslaughter. Yes.
There are, for the record, category 2 lessers that we could argue to the court. We've reviewed them, and there are none that apply. It's the same as when you were talking with Ms. Gowdy.
All right, and that's the same. I think it was done the first time, correct?
Yes, sir.
All right.
Now, does he want the last line there, manslaughter by act? Do you want act capitalized?
What page? I'm sorry.
We're under 3.4. Because you want all of those. You want first degree murder, second degree murder, manslaughter.
Oh,
you want
sure.
all this.
Yeah,
So you
that'll
want
work.
manslaughter by act. Do you want act capitalized or
Yes,
not?
that's the way it's usually done, sure.
Okay.
All right, so then moving on to second degree murder 7.4. And again, I'll read. And if for some reason, I know that I won't forget, but just keep an eye on me. If I start to read one of these where I should have read, this applies to counts 1 and 2, and the victim in count 1 is, and the victim in count 2 is, just alert me. But I think I'll be all right.
And Judge, I think this is the case, but I'm confirming. Will they have their own copy to follow along with you?
No.
Okay.
No. What I do is I send it. I let them know so they don't try to write everything down. That the copy I'm reading from will go back with them. My experience is, and other judges have indicated, that if they have their own with them, then if they either read slower or too fast, they're not going to be on
They're
track
not, they're not
me.
with you.
Right.
Gotcha, okay.
Mr. Grant, are you fine where it says 7 point for murder dash second degree? Are you, okay.
Yeah, no, I was saying the same thing.
Okay.
I didn't care about the in the or the dash. I was just talking about the capitalization
Gotcha, okay.
issue. So no, that's fine.
All right. So, as to the substance of 7.4, any objection from the defense?
I'm scrolling down. I was telling Ms. Johnson that I've looked at these about 482 times, so I'm just double checking again. No objection.
All right. And state.
Objection from the state judge.
All right. So that takes us to page 4, 7.7 manslaughter.
So I think there has to be a decision made, right, on element 2, because you've, of course, still have victim in count 1 and count 2, each of the Goodrone brothers. I think it has to be either 2A or B. I don't know if they get both. And I don't think the facts would be one that would be an issue of culpable negligence.
State, are you at all arguing culpable negligence in this case, or you're arguing intentional?
No, Judge, we were arguing intentional, but the culpable negligence was included last time. I just want to look under the attempted one.
If she's looking, my experience is manslaughter sometimes gets a little bit tricky as to which theory a prosecution goes forward on. And I don't want a jury confused, because at no point in time are we saying Michael Keetley did this. He didn't. That's for tomorrow. Michael Keetley did this, but he was just culpably negligent rather than intentional.
So, Judge, it does say culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm.
My experience has been, Mr. Grant, that, I mean, it's standard and it's given even an intentional. I've never seen it not given. The or, and then the definition of culpable negligence. I mean, I agree that sometimes we over-instruct the juries, but...
This is going to sound far more disagreeable than I mean. I have seen it in cases, so I'm not taking issue with the court. That's why I raise it. If the court wants to give it, I got it.
Well, no,
and I'm not saying, I don't mean, I'm not...
I'd rather read less.
Right, and I understand that. I err on the side of where we can streamline and there's not an issue of confusion.
The question is to the state. If you're not going to argue culpable negligence, why include it? I mean, because then we have that long paragraph on definition of culpable negligence. If that's not your theory, I mean, are you thinking that, oh, maybe the jury will hang on to some other theory that we're not arguing?
Well, Judge, I mean, technically we could, under the facts that have been presented to this jury, culpable, it's knowing reckless disregard of human life or the safety of persons exposed to this dangerous effects. Based upon the facts presented to this jury, yes. Technically, we could argue it.
And I would submit there's a difference between what we can do and what we are going to do. I mean, if that's where they're going to argue for a lesser for Mr. Keetley. It would seem that this would probably be close to...
But look at the last paragraph. I mean, that's still following in the negligent act or omission. I mean, I just don't think it's your theory of the case that it was a...
It's not the theory of the case, I can tell you that. However, let me do some research. I thought that there was some issue about manslaughter as a lesser of what's alleged. I just want to make sure that there's no issue if we get rid of it. It's been a while since I have
Yeah, I mean, it would still include, no one's suggesting you take out A, which is Michael Keetley intentionally committed an act or acts that caused the death of the victim. The second one is the death of the victim was caused by the culpable negligence of Michael Keetley.
I know, Judge, but I thought that there was some weird ruling about that, and I could.
And there may be, and I'm at the
mistaken.
disadvantage of not having my staff attorney next to me who knows all those rulings, and sometimes,
And I could be mistaken as well, but I will double check.
all right, I tell you what, I'll tell you. You know what their request is? If you find something tonight, we'll leave it in right now. If you find something tonight and you acknowledge that, you know what, I mean, that's just not our theory. We're not alleging culpable negligence, and there's not some case that says you shouldn't take it out, then go ahead and make that. We'll announce it tomorrow. We'll make sure. That'll be fairly quick. Or if you want to have two versions, either way, because that would eliminate that B and then those two paragraphs.
Yes, Your Honor.
All right. So moving on, any other issues with that instruction?
Not from the defense.
All right.
Nothing else from the state.
All right, moving on to page 5, introduction to attempted homicide, which applies to counts 3, 4, and 5, and then I'll read who the, and 6, and who the victims are in each of those, and then the language regarding justifiable attempted homicide and excusable attempted homicide.
No objection there. My question is, I've seen, again, judges do differently. Do you read that? Again, I've seen some judges say the instructions go back with you, the instructions on attempted are the same as I've read before. Some judges read every page.
I'm going to read it.
Okay.
Yeah, I mean,
That's fine.
I read a lot of redundant stuff, and, I don't think it hurts.
No, sir, I just wanted to know how you do it.
Yeah, I'm going to do it the way it is here,
Okay.
which is reading it now again, instead of saying as you've previously been instructed. So, State, you all right with it too?
Yes, Your Honor.
So that takes us to 6.2 on page 6. Any objection to attempted murder first degree premeditated?
No, sir, I'd note the state's done the same thing as last time, and I think you'll do this as last time and previously discussed on counts 1 and 2. They'll say this applies to 3, 4, 5, and 6 and those victims.
Right.
So there's a good consistency there.
Yeah, and I have no doubt we did it this way the last time. I like it because I don't have to read it 6 times.
Right.
Which is, I think, the other way to do it. And I don't think it's confusing. I mean, it seems to make sense. I don't think it's going to confuse the jury.
Correct.
Because all we're doing is we're using the word victim in the substantive, element, and then that's defined for them right above. The victim in count 3 is Gonzalo Guevara. The victim
No,
in count
it works too, because I think the jury verdict form will say count 3 and then the name of the victim and whatnot. So
Yeah, it does. It becomes even clearer with the verdict form.
Right.
All right, State, no objection to 6.2?
No objection, Your Honor.
All right, moving on to 6.4 at the bottom of page 6. Mr. Grant?
6.4. Sorry, I scrolled down. Yes, I've reviewed this. I have no objection.
State good with 6.4?
Yes, Your Honor.
6.6 on page 7.
We still may have that issue of the. I think we have to reconcile the issue of intentional act or negligence. That may cause some change to this. Maybe paragraph 3, the defendant cannot be guilty of attempted manslaughter by committing a merely negligent act. Every person.
Well, you want that.
Yeah. Maybe we just leave it all in, as you said, and over-instruct them. How about that?
Yeah, I mean, there is some beneficial language to the defense, so maybe we should just leave it in the first
Let's
one.
just leave it. Then let's just leave it all.
Yeah.
So we're leaving it,
Yeah, we'll leave the. We can go back to
7.7, we're leaving all of that.
Right.
Yes.
Your Honor. Yes, Mr. Chairman.
And that's the only way I've seen it done. I've never seen it. I think we could carve it out, but you take out then that instruction that a defendant cannot be convicted by a merely negligent act comes out too. So, And that might be what Ms. Doherty's talking about. Maybe somebody carved it out and they said, no, you know what, it shouldn't have been carved out. So that takes us to page 8, 3.3a, felony by carrying a firearm.
So our 1020 life language.
Yeah, this is the enhancement language, and I'll read what's in parentheses. This applies to the offense of first-degree murder, second-degree murder, attempted first-degree murder, and then that'll become clear also in the verdict form where they have the interrogatory, I suspect, to be able to answer that.
Right.
So you're good with 3.3a?
Yes, sir. That's
And
the
state?
standard language.
Yes, Your Honor.
All right, 3.3b.
Yes, because I think manslaughter gives the 1020 life possession, but not the discharge or whatnot. So yes, that's standard.
Yeah, it looks right to me. State agree?
Yes, Your Honor.
Good
And
point.
by the way, sorry, just to make sure the record is clear, not only not objecting, these are what were given last time too. So there was a lot of careful
I agree.
conversation with you and the attorneys back then. So
I agree. 3.3d, possession of firearm and discharge causing death.
3.3b, right?
D.
D. Sorry.
It's still on page 8.
I don't know why I did that. 3. Oh, okay, sorry. I got confused. We just did 3.3b. Now on to 3.3d. Sorry. Yes. No objection.
State.
No objection.
Turning to page 9, 3.3. Why is there another D? We just did 3.3d on page 8. Now on page 9. Oh, I'm sorry.
Oh,
Because that was to counts 1 and 2.
It
Now it's to
applies
counts
to
3,
the-
4, 5, and 6. Defense good?
Yes, sir.
State good?
Yes, Your Honor.
3.6 alibi on page 10.
I included that because that was included in the last time, but I don't know if any facts were presented regarding that.
Connie Bell presented that the computer was being used at some other time, so we should leave that in. And because they didn't get the MiFi hotspot, they can't say where it is.
I mean, technically, I suspect that the defense theory is that he wasn't there. And so the beginning of that alibi instruction, an issue in this case is whether the defendant was present when the crime allegedly was committed,
Right, because
is a
sometimes
correct statement.
sometimes you have a defense where the defendant was at the scene of a crime, but he did not do the crime, right? Wrong place, wrong time, right? That's not the defense in this case. We've said that Michael Keetley did not do it. He could not do it. And the computer evidence from the state backs that up, and that the computer was being used at...
Alibi is an affirmative defense, though. The defense has to file a notice of alibi and then has a burden of
Well,
presenting
we'd have-
some evidence of alibi.
It is an affirmative defense, you're correct, but the state has to demand an alibi or file a motion for statement of particulars. And if you're going to ask me what happened in this 12-year-old case at this point in time, I am quite confident a lawyer such as Leanne Gowdy would have responded to a demand for a statement of particulars or whatnot. So I don't know that there was ever a demand put in place.
All right, so the defense wants it.
Yes.
Technically state, these are your proposed instructions. Are you objecting to it?
No, Judge, again,
No, I hear you. I hear you.
I
It's
wanted to bring
I
up
know.
any facts.
I have the same, but if they're requesting it, it was in there, it was given last time. Let's go ahead and give it an abundance
That's
of
fine,
caution.
Your Honor.
3.7, plea of not guilty.
That's standard. No objection.
State agree? Yes, Your Honor.
Page 11, 3.9, weighing the evidence.
You're right. So all of a sudden I was just looking for a statute book because I know we have, under there, we have 1 through 10. And I cannot remember what
two were taken
what
out?
2 were taken out. So,
Ms. Johnson, do you know which 2 were taken
and
out?
I've got the standard instructions I can pull up too. which number was that again? 3.9, right?
Yes.
Okay, so under weighing the evidence, we have the first 5, which are standard, and the question number 6, has received any money, preferred treatment? Yes, that comes in. And I'm not comparing to what we have there. Pressure or threat used against the witness to affect the truth of their testimony?
Is that not here?
I don't know. Going back.
That one is not on here. I can add it if you need me to.
Yeah, the defense want it?
Yes.
The pressure or threat.
Yes.
All right, so add it.
Inconsistent statement, and again, I'm going right now by the standard, so I don't know.
That's in here. That's
That
at
should be in
7.
there. Okay, when I'm calling them out, I don't know if they're in or not because of when they're conviction.
So I'm sorry, what number is the pressure or threat going to become?
Well, that would be number 7,
Pressure or threat's going to be number 7, okay?
and then the inconsistent statement would be 8.
Okay,
Witness been convicted of a felony or misdemeanor, that's 9.
okay.
And then 10, I do not think applies, and I don't think it would be in there. This is your general reputation for dishonesty or truthfulness. There's
All right,
no-
that's not in here. So you're
Correct.
going to insert the one that they requested, and that's going to bump everything down, or those from that forward down a number, making 7, 8, and 8, 9.
Yes, Your Honor.
Let me just take this a minute from. Hey, I'm in my courtroom doing jury instructions. Do you want to come up here? No, not too long. It's up to you. Well, I mean, if you want to come up here, and then we'll walk down when I'm done. Courtroom 51. All right, bye. All right. So the rest of that 3.9.
3.9B, I think we've
No.
accomplished. 3.9 we did, and then we go to 3.9C.
C on page 12.
Correct. Judge, if I may, I'm going to be quick about this. I had conversation with Ms. Johnson before as to the eyewitness identification instruction. I would like the current instruction to be read. The instruction did change. I understand that this was heavily litigated last time, and the court went with that which was in place in 2010. I looked at case law. 285 Southern 3rd, 1003 is a case of Williams versus State. That's probably was a conversation point last time. I unfortunately brought one copy. I told Ms. Johnson about it. She says, no, I'm well aware of it because unfortunately I'm reporting to you for Mr. Keetley that this does not help his position. The addition to the eyewitness testimony talks about what the requirements are now in the law. And unfortunately,
They weren't in the law
they
then.
were not in place at the time. And this is a great reason why they should have been, but that's, argument. But I would like the court to consider either giving that or giving a shaved down version of that, since eyewitness testimony is highly suspect and in doubt and subject to argument in this case.
Well, I think it was litigated last time, and my ruling is going to be the same, but it's preserved.
Thank you. I object to that and ask you to reconsider your rulings. I understand that you have done so.
Yeah, I mean, I remember now. We talked about that a lot in the case law. State, you're sticking to your prior position regarding that instruction?
Yes, Judge, there's that first DCA, the Williams case, that's direction and point.
Okay.
That's the one I cited.
Yeah.
I mean, technically, if there's no conflict, if there was conflicting, I might be able to go differently, but
Well, and I do think, I understand your ruling. It's a cautionary point for all of us, and we'll be working with Mr. Escobar tonight, but it's a cautionary point that what we can and cannot say in argument before the jury, because we do know that this is the law now. And I think it is analogous to subsequent remedial measures. Why do businesses fix problems, to make people safe? If they are going to hit with that in court, they
I
will
hear
fix
you,
it.
and I don't,
Yeah.
but I'm going to follow that first DCA case.
Okay.
3.9A, defendant not testifying.
That goes in, of course.
3.9B, defendant's statements.
3.9 Bravo, yes, that is standard.
3.10, I'm sorry, rules for deliberation 1 through 7.
Standard, no objection.
3.11, cautionary instruction.
Yes, no objection, standard.
3.12, verdict.
That is correct. I think we'll talk about the verdict form separately, but yes, no objection.
Yeah, we're going to talk about the verdict form
Where do
now.
you want
State,
this-
you agree with all of those as
Yes.
well?
Oh, she's about to ask
Where
about an
do you want-
interpreter.
Where do you want that to go?
I would, if I can make a suggestion.
We're going to put it wherever you say you want it.
Oh, sorry, you just gave me so many options. I would suggest that we would probably want to do it.
Right around
Just
that rules for deliberation.
Yeah, well,
maybe.
either rules for deliberation, but I was also thinking weighing the evidence, because that deals with witness testimony. So
Yeah.
I was thinking. Sorry, I'm scrolling. If you get the plea of guilty, reasonable doubt, burden of proof, now you got weighing the evidence. It's up to you to decide which evidence is reliable, and then you can. Right after that, right before eyewitness identification. Does that seem like a good spot?
I agree. I think that's a good spot. Ms. Johnson, any objection?
No, Your Honor, so right before 3.9C.
That's
Correct.
correct. Right after 3.9, right before 3.9C.
We'll do
That's where you want it, Mr. Grant, right?
That's where I think it's best. Yes. Sir.
I don't disagree with you. So now the verdict form. It is a number of pages. What I'm going to ask, Ms. Johnson, that you do is you not number, that be the numbering be stopped so that the first page of the verdict is not page 15 of 23.
Yes, Your Honor.
I just don't want any numbers on the verdict form. Any
yes.
objection to that, Mr.
No, I don't want pagination on the verdict form.
Right. I've never done that. We always take it off.
So I'm
but-
not going to number any of the pages probably, Judge.
And that's fine too. Well, I mean,
I would suggest that we do. The
yeah,
jury
if
instructs
they drop them back there, it's just I don't trust them not being right in the right order. So if you can, I know. I think what you got to do is separate documents.
I'm going to, well, is the JA okay because she wanted one full packet?
No, you're fine. If you send me the verdict form
Separate,
separate, that's
okay?
fine.
Yeah, that's the
Because
way
he
we
pulls-
always do it.
Yeah, because he pulls it out anyway, so that's not a problem at all.
Okay.
All right, Mr. Grant, have you looked? For our purposes now, we have a number on it, and it's pages 15
of
through
23. Right, that's where we are currently. So yes, this is. I'm sorry, I'm confirming what Ms. Johnson.
It's
confirmed
15
before you.
through 21.
Right. So the defendant is guilty of. This is how we've got it. Defendant is guilty of murder of the first degree as charged, and then we have did the defendant personally carry, display, use, actually possess. Or defendant discharge, and did the discharge cause the death? So that's the way you amended it, right?
Yes, because they did the separate interrogatory findings on a separate document last time. That
Good.
I felt like it was.
I like this.
Yes.
Yeah.
You're all right with this,
No,
Mr.
this
Grant?
this works. I'm seeing more and more of this in these types of cases with the interrogatories.
I think it's a lot cleaner.
Now, we do need to fix the one on manslaughter, but that's on the next page. Because I put firearm, but I think it's more, I think we have to put weapon, not firearm, on the lesser for C. For the interrogatory. So on page 16 of 23, C, it needs to say, did the defendant personally carry, display, use, threaten, or attempt to use a weapon?
Yeah, I'm trying to remember my manslaughter. It's always goofy there. So
There's no manslaughter with a firearm, it's manslaughter with
right,
a
it's
weapon.
always manslaughter with a weapon.
And the weapon includes, so when you go to
The weapon includes the
definitions-
definition of firearm. I got that,
Right.
but that's for the 10. That's for the 10. I think that's what they're saying is correct.
So, are you all in agreement?
It's got to be changed to firearm. So yes, changed from firearm
To weapon.
to weapon.
So you're going to make that change?
I apologize, Your Honor.
You're going to make that change?
Yes, Judge, so I'm going to fix that on page 16.
Right.
I'm going to fix that on page 17. And then also for the attempts, it would need to be weapon for every. Also
Instead of
attempted
firearm.
manslaughter. Yes.
And read it to me again. How is it going to say it? It's not discharge a weapon. It's
No, so just looking at page 16, Judge, for count 1. Still in count 1, it's letter C.
right.
It says the defendant is guilty of manslaughter, a lesser included offense. And 1, did the defendant personally carry, display, use, threaten, or attempt to use
A weapon. Okay.
Yes or no?
You're in agreement, Mr. Grant?
Yes.
Okay. And you're going to make that change throughout on
For
all
every
the counts
manslaughter.
where manslaughter.
Yes, Your Honor.
Mr. Grant, was there anything else? Because they all read pretty much the same.
Correct. So the answer, I don't believe so. Let me.
The only thing that's different is the victim, which is specifically identified in each count, in parentheses. And
Correct.
I'm going to read all of that to them, and obviously they'll have it with them and they can see.
Correct. I have. If the court's concerned about the presentation of any of this, I don't think there's an issue. I have seen sometimes before where there are page breaks between each count. I don't know that that's.
Nah, we'll save paper this
I
way.
gotcha.
I mean, unless you're requesting it and jumping up and down, and if so, I'll as I said, I'll defer.
All
right.
I'm just trying to.
What I don't like, if there's something left hanging or like just a signature, then I'll address that. But I don't have a problem with the way it is. Anything else on the verdict form?
No, sir.
And let me just make sure. Yes, there is, on the last page, the signature page, there is a C and a D, which is what I want. I didn't want just a hanging signature page with just the signature itself.
Right.
3.12a, page 22 of 23. It won't be 22 anymore when we take out
Right.
the verdict. It'll be
Yeah,
page 17, I think.
That's standard, single defendant, multiple counts or information, so that's standard.
All right. Now, what we need to do, State, is I don't see it in here, but usually the first instruction is the defense and the state have rested, the state and the defense have rested their case. The attorneys will now present their closing argument. That needs to go now at the end, there.
At the end,
Right.
closing.
But not but before 3.13, because then after the closing arguments is when I read 3.13.
So I'll add it to right under 3.12a.
Right.
Yes, Your Honor.
And Mr. Grant, you agree?
Yes, sir.
So that leaves then 3.13, submitting case to jury.
Which is standard and no objection.
And that's the last thing that I'm going to read to them after the closing arguments are given. And then I'll excuse the alternates who, we'll go over that again in the morning. I don't know where my chart is, but here it is. This could change because, I mean, if somebody doesn't come or there's some emergency. But right now, our alternates are seated in seat number 11, 14, and 15.
That's my understanding.
All right. And I don't have a problem with you all approaching because, like I said, that's still subject to change. If for some reason we lose a juror, doesn't come tomorrow, there's an emergency or something, that's going to change. But as of right now, our alternates are seated in seat 11, 14, and 15.
And I didn't know if one of the juror that usually has to leave at 5:30, she was making a face when you said.
Well, I'll talk to
So
her.
I didn't know what, if she said anything to the bailiffs, and I see.
What seat was she in?
She's in seat 12.
Yes.
She said that she cannot stay past 5:30. She has no child care. She has
Tomorrow?
Yes.
Oh, well, that's a serious issue,
Yeah.
but I don't know if you all are comfortable doing that now. I mean,
I'd rather wait till tomorrow.
I'd rather wait till
Talk about
tomorrow
that.
morning.
all right, well, you all talk about it, but I will tell you that I am not comfortable concluding the deliberations tomorrow at 5:30.
No,
Okay,
not at all.
all right. But that's the issue, so you know, and so be prepared to address it in the morning. We don't need to address it now. Okay. Okay. No, yeah, I appreciate that. She said that she has no alternative. So, I mean, if you want to pull her out tomorrow when she gets here and talk to her, that's fine. But she indicated to the bailiff that no can do past 5:30.
I hear you.
Not going to work.
I hear you, and I'm going to talk to the team that abandoned me, and they're all partying right now.
No, I know. Well, and honestly, I have to go. I have to be somewhere at 5:30. I know we have the two proposed instructions. I know that you all have submitted case law, and I will read it tonight and let you know in the morning. What, if anything, do you want to say about? You gave it to me. Do you know where it's at now? Here it is. I've got it. The adverse inference instruction is what's being requested by the, well, yeah, well, no, that's the standard. It's a civil 301.11, failure to maintain evidence or keep a record, but you've typed them up into two proposed special instructions.
Yes, sir. Yes, sir. One on the adverse inference and one basically on the issue of spoliation, which we titled differently because you don't see spoliation or spoliation, however you say it. I've heard it
Is that
different
the one
ways.
you've typed up as proposed jury instruction on Roney?
The adverse inference is on the hot spot. The other one would be the Roney. Because there's no evidence.
Well, the hot spot is more of the spoliation issue.
Correct. I may have
Okay.
had it backwards. It was correct in here, and then it came through here. And it may not have been correct at that last stop. So yes, you are right. We've got the issue here where they had that hot spot since day 2 of this investigation.
They didn't know about it until it popped out at the trial.
That's what they say. I got it, but
They
that's
would have
not,
acted
that's not actually.
differently had
That's
they known about it.
Well, actually, that's not true because they sent a preservation letter sometime before that, if I understand correctly. They sent a
Regarding the
yes, regarding the router. I think it's. I'm looking at him. He knows the case better than me. But don't say anything. But I think they sent a preservation letter. You actually heard argument from that from the state. So they knew about it before the trial. And
But
you know,
there's-
and here's the problem. Here's the problem. Had and I can say, had we been on the case, or had we had the availability, and I'm not just saying Escobar, Grant, and the rest of us, you know, you got Leanne Gowdy here, and you know when she's going to get the discovery, and she's going to see that, she doesn't have the ability to go say, hey, let's get this thing tested. By the time it becomes aware to us, it's in their care, it's in their custody, it's in their control. And whether they know about it, they certainly should have known about it. And so we don't have the ability to do what we would have loved to do, which is run those router records to conclusively show that Michael Keetley was not there. They're at a place now where they're suggesting he's driving around and going on a dating website just a couple more minutes before a shooting in a mobile router. When Ronald Witt said, not going to work so well. So, I mean, that's the issue there.
There's no duty, though, for them to subpoena those records.
I'm going to thoroughly disagree. And I'm saying that as a guy who once prosecuted for quite a long time. Absolutely not. You're going to... I'll get off my high horse. I'll just say disagree.
State?
Judge, I just would argue the multiple cases I cited to regarding what the 3 requirements are, and based upon.
Well, but this is kind of a different
So the
issue.
spoliation, so the testimony was that it has to be sent a subpoena within 30, 60, 90 days. There was nothing made even remotely aware to law enforcement that potentially there could be evidence on that until 2016, is my understanding. And at that point, they did attempt to get information, but they already had the cell phone dump that was done that provides timing issues that defense counsel has repeatedly tried to bring up, that there's this 2:30
Well, their
messaging.
issue is Towers. Which
Towers,
What
correct.
Towers that card would have been bouncing off of.
Correct. They went.
What they need to show is that it's materially exculpatory, and then it was done in bad faith, which they cannot show.
I don't think that, I disagree with that standing. It talks about whether there's sufficient instructions to allow. Some of the cases they talked about based on a theory of the defense, they, being the appellate court, said the standard instructions suffice. Here we have the Towers, which they're trying to argue this hotspot was being used by Michael Keetley in Ruskin a few minutes before, without one stitch of evidence to support that, right? So, we didn't have the ability to go and get those. They brought the guy. Well, it may not have been him, so it may have been a different company. But whoever it was that for the Verizon Wi-Fi, they could have gotten those records. They could have seen where the towers were going. They could have done all of that, and they did not do that. Had they done that, we would have not been here because it would have shown he was at home.
But the defense was in the best position to know if the computer was at home being used by a router that was bouncing off of Towers, and could have investigated that.
Have you ever seen any time where the prosecutors and the police will go, yeah, sure, here, you can have our evidence? No. That's not going to be the case. And by the way, I'm not sure that they're
if
correct.
It's the defense position that Mr. Keetley was at home using that router, and it's going to show that it was bouncing off of Towers next to his house, the defense was in possession of that information because Michael Keetley is the defendant.
That's going to presume, if what they're saying is correct, at 30 or 60 or 90 days, that's all the time they have, and I disagree with that. But there's not any indication that we got all the discovery. I have many homicide cases where I don't get discovery for 4 months because it's still coming in. So you cannot assume or accept as certain that we even had that discovery at that time. This prevents the state
The
of...
defense could have just as easily sent a preservation letter regarding those records. Are you? And that's where I'm a little lost. Are you telling me the state sent a preservation letter within the night? They didn't send it within the 90 days.
No,
That's why
I think it was 5 years.
Right.
It was some 5 years.
Okay, but if the defense knew that Mr. Keetley was at home using that computer, they could have sent a preservation letter.
That's a potential. I got it. But is it on us to do that? If we did or didn't do it, whether that was wise or unwise, I wasn't there at the time. I think that was just Mr. Carr at the time.
I've just never seen where the state has an obligation. Sometimes they do, depending on how, the investigation, how diligent the investigator is, going up and down the street and getting, what are those bell ringer cameras? But
Right.
and if they don't do it, then now the defense in every case where the investigator doesn't get every ring camera in the neighborhood is entitled to a spoliation instruction?
I don't think that respectfully is on point. They, being the state, are going to argue that this hotspot was being used by Michael Keetley in Ruskin at the time of the event. That's a significant fact, right? So if we were going to add something significant about ring cameras or door cameras would have shown, yeah, The issue here is they are going to argue without any supporting evidence that something
in
exists.
those ring camera cases, are you telling me that the state is not arguing that the defendant was at the scene of the crime? Let's say there's a murder in the middle of a block, okay?
Yeah.
And they're prosecuting him. So
Right.
they're saying he was there at the date of the time.
Correct.
And if they didn't go and get every ring camera, you're suggesting that then the defense would be entitled to a spoliation instruction
No.
on every ring camera they didn't get.
No, that's not what I'm saying. In fact, I would argue that the state doesn't have that obligation. But if the state, in your example, starts arguing that the ring camera showed, and they didn't get it, heck yes. They don't get the benefit of arguing that evidence exists when they can't prove
But
that
they're
it
not.
exists.
They can't argue that it shows that he was there.
That's
they
what
just
they're gonna
don't.
argue.
They can't argue that because they don't have it.
Okay, so if I or Mr. Escobar object to that tomorrow in closing argument, will that be sustained?
Well, they're not arguing that there's records, cell tower records, that suggest that he was there because they don't have it, and they can't argue that. It's not there.
Right, but they're going to argue he's on the router at the time without anything to support it.
Just like they would argue that he was there at the time, and the response would be
Hang on.
if he was there at the time, he'd be on the...
I got it. I'm taking Mr. Escobar's closing argument from him.
It's preserved for the record. I'm not giving it.
Okay,
I'm not
all
giving
right.
a spoliation.
All right,
And
great.
I'm not suggesting that there isn't an appropriate time, because there are some. The bench is divided on whether spoliation instruction is even appropriate in a criminal case. It's a civil instruction. I do think that if, let's say, for example, they had subpoenaed the records, or they had gotten a warrant and they got the records, and then they lost them, I'd give a spoliation instruction. But they never got the records. And I understand the situation that it's in, but it also hurts their case because they don't have the evidence to prove that he was there. If their theory of the case is right, that he was there and he was using it. And I suspect that, again, Mr. Escobar is going to do an excellent opportunity of arguing that there's no way that he was there on a dating site 5 minutes before he went and committed this crime. So, again.
I understand. I understand. I think the record should be clear. You've given me a chance to argue. You've considered all of my stuff. I really disagree with you, and I say that in a very respectful way.
I understand.
The issue is, I think, settled.
I know. I've thought about it, and this isn't the first time I've thought about it. I've thought about it in many cases.
Well, we've had. Well, I know you mentioned spoliation in maybe other cases as well, but certainly you've been around.
Very familiar with spoliation. What we have here is the investigator or the state's failure to secure evidence that they believe, under their theory, would have been beneficial to them. And your position is that under our theory, it would have been beneficial to us.
Right.
But nobody got it. And I'm suggesting that if the defense knew that he was sitting in the house, and he's the defendant, using his air card in his house, that the defense had just as much opportunity to secure those cell tower records.
I understand where the court's coming. I think that's a dangerous thing to be heard from a prosecutor to a jury, but I understand what you're saying as far as it relates to that.
I mean, it would be very helpful. I know that it would be very helpful to one side or the other. But not having them, don't know which side it's helpful to. So you can argue all the rest of the evidence. I'm not giving an instruction on.
I understand. The other issue is Roney. Apparently, you've got to get going. But the issue with the Roney is, at the time we had Wesley Smith's limited testimony, there was some belief or some hope by the state attorney's office that they would have Jay Ports come in and say this Roney was in existence. Of course, we know when they flew him all the way down from Pennsylvania. He sat there and said, "I can't tell you that it existed." So we did not put him up on the stand because it was going to be a question, because the catalog went from, it suggested it wasn't because it says coming in 2021. When they're talking about a modification or a Roney or anything, there's not one bit of evidence to support this idea of a modification. And so that's why we're asking for that jury instruction as it relates to the Roney. There's no evidence of a purchase. But Wesley Smith's testimony, if you're going to believe it at face value, given its best benefit is, hey, Michael Keetley came and talked to me about buying a modification. They didn't run a credit card check. They didn't run anything. They have no evidence to show that Mr. Keetley bought a Roney, a Bologna, a Maroni, anything. They don't have anything to show that he bought anything. He didn't. The only thing he bought was a .22 starter rifle fit for a child.
Ms. Johnson?
Judge, I would argue this is more a statement of fact than even a statement of law. With regards to the Roni, just as much as Mr. Forks couldn't say with 100% certainty that the Roni was on the market and for sale, he couldn't say with a 100% certainty that it was not. These were not facts placed before the jury, so it would not be appropriate for you to make this statement. It would be confusing to the jury to hear something like this. What they heard about the Roni came from defense counsel first. The state never even mentioned anything about a Roni. It only came out during cross-examination through Mr. Escobar and Mr. Wesley Smith. And this is purely can be made an argument. It would be improper and inappropriate to instruct the jury as to this special instruction.
But we instruct juries all the time when there is a statement that comes in that should be disregarded to disregard that. And that's what we're asking to be done. Because Wesley Smith comes up here at a time he cannot recall, in a statement he's not sure about, that Michael Keetley somehow did this. And by the way, that was 12 years after the fact, and after he watched all this stuff on Yahoo or YouTube or whatever. And so there's not any evidence at all that Michael Keetley purchased a modification kit, a pistol housing unit, a Roni, whatever you want to call it. Not one bit at all.
But that doesn't mean it wasn't on the market, Judge.
All right, I'm well aware of the three things that you have to show in order to get a special instruction, and all of the case law that suggests that in criminal trials the standard jury instructions are presumed correct and are preferred over special instructions. In order to establish the entitlement to a special jury instruction, defendant must prove 1, the special instruction was supported by the evidence, 2, the standard instruction did not adequately cover the theory of defense, and 3, the special instruction was a correct statement of the law. Here, I hear what you're arguing regarding the lack of evidence of a Roni or the non-existence of a Roni, but it's clearly covered in 3.7, plea of not guilty, reasonable doubt, burden of proof. I've just read the instruction, and it's where they have the burden of proving that it was committed and that he committed it, and it talks about how conflicts in the reasonable doubt, beyond a reasonable doubt, and reasonable doubt can come from then the charge is not proved beyond every reasonable doubt. You must find him not guilty. It is to the evidence introduced into this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of Michael Keetley may arise from the evidence, from conflicts in the evidence, or from a lack of evidence. And what you just told me is there's no evidence that he bought a Roni, that he had a Roni, that I had a Roni. That's argument to the jury to create reasonable doubt under a lack of evidence. So I think it's covered by the standard instruction.
Fair enough. Thank you for letting me argue. The last thing I'll say, and I'll really get you out of here, because I wanted to talk to to Rick Escobar and to Kim Kahn to confirm with Judge Gowdy. There apparently was a circumstantial evidence instruction that, from what it appears in constructing with Ms. Johnson, that may have been submitted last time. And I can email it to you if you'd like.
Yeah.
Because we could not tell whether it was given or not. It appears, and I think the state's position was, it was submitted in a conversation like this. You declined. I don't know. But
I don't remember.
I'll forward that to you if you don't mind.
Is the circumstantial evidence instruction a standard instruction, or was it?
It is not. It appears that it was a proposed instruction by the defense.
And there is case law that says that's come up. There's case law on point on that says that the standard instructions cover that. There used to be a standard circumstantial evidence instruction.
And it's not
It was
around.
eliminated by the Supreme Court, and now where defendants have requested it and the courts have rejected it, the appellate courts have said that it's covered, and I think it's actually that same instruction that I just read that they say covers it. You can argue it under the reasonable doubt.
Yes, sir.
Says reasonable doubt and burden of proof now cover that old circumstantial.
It says it in the standards.
Yeah. And Judge, I have that case that says that, Judge, and I can give a copy to defense counsel and to your honor. It's Williams v. State 437 Southern 2nd 133.
I'll still, we don't need to argue it anymore now. I'll look at the case law, and I know you're moving to a new meeting. What I'll do is I'll still send you that circumstantial evidence. I'll look at this case law, and
Not a problem.
that,
Not a problem.
that may.
Yeah.
And
And
Judge,
you
that
can-
defense, Ms. Gowdy did hand up the proposed circumstantial instruction to your honor. It was argued last time, and your honor said
Well, and that may be why I remember so clearly all of this. It may be from that case or another case, but I remember the case law. It says that it's covered, and it used to be a standard and is no longer recognized. All right, well, we're in good shape. 8:30 tomorrow. If there's any last-minute things we need to make, we can certainly do those. Did Judge Azarian come up? He said it was coming up. Did he get lost?
You might be
Oh, okay. All right.
So, Judge, the only other jury instruction we're going to be addressing tomorrow is the circumstantial evidence. That's it.
I believe so.
I don't have any. I think you've ruled on.
Yes.
And I'll print everybody copies. Once I get them, I'll print you all copies.
I'll email it tonight.
Thank
All right, thank you all very much. Appreciate it.